Добрий ранок, пан Роман. Good morning, everyone. Today we are going to continue our interviews with our candidates for the position of disciplinary inspector. And today we have Mr. Roman Login in our interview. So first of all, I would like to inform you that the interview will be conducted by the Selection Commission. I'm Reda Moliene, the chair of the commission, and also today we have all commission present. Members of the commission, Yulia Bokova, Olena Kovbi, Olha Popikova, Pavel Zelinchik, and John Ehrlich. Do you have any requests regarding the composition of the commission? Thank you. So the interview will last for about an hour approximately. It's shorter than the previous interviews for two positions, because this interview for one position for the disciplinary inspectors, and we will ask you some questions about your professional competence, skills, ethics, understanding of judicial ethics, and at the end of the interview you will have several minutes for final comments and remarks. The interview is broadcasted, as probably you know, and some of the parts of the interview could be held not in public if there is some information which falls under restrictions of the martial law for its public disclosure. So if there are parts of the interview where we should consider this issue, please inform the Commission when. So maybe you have any questions so far? No questions so far, so we can start with your introduction. You have up to 10 minutes for the presentation of your background, your motivation, your understanding of this service and its mission. Thank you.
Microphone. Distinguished commissioners, distinguished chair, thank you for the opportunity to be here today with you and the opportunity to participate in the competition for the position of a disciplinary inspector in the SDI. I graduated from Lviv National University, named after Ivan Franko. I received the master's degree in law. Then I graduated from Lublin School for Innovations. I have experience. I worked at an operative positions in investigative authorities, SBI, and the National Police of Ukraine. My understanding of the service and its mission. We all know that according to the Article 8 of the Constitution of Ukraine, the rule of law principle is effective in Ukraine, and the rule of law is valid in Ukraine. And I believe that the mission of the SDI is to continue to further the rule of law in disciplinary proceedings, to carry out them in a complete way. This mission can be achieved with the following. Firstly is the access of citizens. According to the law of Ukraine, any citizen can initiate a disciplinary complaint against the behavior or actions of a judge, or when the judge administers justice, or against extrajudicial relations. The second tool to achieve the mission is, in my view, the fact that the SDI needs to create precedents that may lead to certain amendments, and that would be a kind of a preventive function for the current judges, so that they avoid violations of the Code of Judicial Ethics and the principles of the integrity by the current judges. Also, I think the SDI is being launched today along with the appointment of judges from the competition of 2017. So the judges, the current judges who have taken the oath or are waiting to take the oath now, they have all kinds of information about the structural unit within the ACJ. They know clearly the authorities they have according to the law, and they understand that they should avoid indecent actions when they pass decisions in their proceedings. The benefit of this service must be very high, because the SDI in an indirect manner is prescribed in the Constitution of Ukraine in the section on justice that says that a judge may be subjected to disciplinary proceedings. It is expressed in an indirect form, yet that's what we've got. And another important principle of the mission of the SDI is to ruin the stereotypes in our society that a judge can't be brought to the responsibility. I think this is a really important thing, and to support my words, I can say that the competition for the position of inspectors in the SDI is very much popular. It has been widely covered by the media, on the website of the HCJ and other websites. So a lot of experts, legal experts, could apply to participate in this competition and take this position and make decisions in the future that will strengthen the rule of law in Ukraine and ensure the fundamental principles set out in the European Convention on Human Rights and the Constitution of Ukraine. So this is it in terms of my understanding of this service.
Our questions, and I give a floor to our Commission member Olena Kovby to start our session of questions.
Дякую, пані Реда.
Thank you, Reda. A good morning, Roman. At this stage of the competition, you are almost a winner because you made it to this stage. And if you don't mind, let's start with questions. You say the competition has been widely covered and all the professional lawyers, legal experts could apply. Do you believe you are a professional legal expert able to take this position? Yes, I do. I believe I meet the criteria to take the position of inspector in this service. The practical task point and the score that you gained is kind of low. Can you explain it? It's 38.4. Well, yes, I can. I've been working in the pre-trial investigation bodies, and I work with courts only when I file motions. The investigators do not attend court sessions. I never was summoned to be interviewed in court, and in the practical assignment, we needed to assess the actions of a judge during a pre-trial, during investigation of the actions of the defendant. So maybe at this point of time I didn't know much. So I understand. So you don't know in depth the how the judicial system works, but at the same time you believe you can consider disciplinary complaints against judges. Yes, I can, because there is also the case law. There is that's everything. I'm not afraid of that. Do you understand? You're gonna follow some templates or something? Well, not templates. I need to take into account the precedents, of course, and the case law that has emerged over the period of my professional work, and I will analyze the legislation that will be the basis for drafting decisions that would be later transferred to the SCJ. The disciplinary inspector, shall he draft the decisions? Well, he drafts the resolutions, of course, the opinions. In your presentation, you say you spoke about the mission of this service. So, what is the main goal of the SDI, in your opinion? Not the way it is prescribed in the law, but in your opinion, what is the main objective or the goal of establishment of the SDI? The main objective is to bring judges to responsibility based on the principle of proportionality. If they committed a violation of some disciplinary standards, then there will be sanctions applied to them under the law of Ukraine on the judiciary and status of judges. Do I understand correctly that once the disciplinary complaint is received, the result will be bringing judge to responsibility? Not necessarily. If indeed the disciplinary misconduct has been established, then the judge can be brought to this responsibility. This is the goal behind the establishment of the SDI. But what is your mission? How do you see your role in the SDI? What can you contribute to the service on the position of an inspector? I can contribute by creating the case law practice, by drafting the decisions for the HCJ, that will be applied against particular judge. But do you mean that the HCJ is passing illegal and unlawful decisions now? Well, no, the decisions are lawful and are legit, but I think I can contribute more to that. Okay. Before I pass the floor to my colleagues, I wanted to ask you about such an interesting story in your life, in particular employment. After you graduated from a university, you started working with a charitable organization, Committee for Combating Corruption in State and Law Enforcement Bodies of Ukraine, and you were appointed straight away to the position of a head of the legal department. Can you please talk to us about this organization, what is its goal, why it was established, and what were your main tasks, what your main duties? Well, it's a non-profit charitable organization. It was 2018, March 2018. There was a competition announced for the position of investigators with the State Bureau of Investigation, and it was over in November. And I immediately wanted to apply and to gain experience, to understand how the pre-trial process looks like, how the in general the criminal justice process looks like. You mean a pre-trial investigation, but it's charitable organization. Do they do that too? Well, no. The getting legal skills, and that was important for me to be able to apply later to the SBI, because I worked with actual documents. I saw how they looked like. I drafted requests. I provided consultation to people. So in practical terms, I was studying the criminal procedure code, criminal code of Ukraine. I understand. How did you manage it to get the position of a head of the legal department? You were a graduate just recently. Well, the other applicants were the students back then, and I had already a master's degree. That's why they appointed me to the position of the head of the legal department. How did you manage to persuade your employer that you are indeed a person that can work as a head without any experience? Yes, I managed that. It was an interview with the head of the organization. Without any experience, how did you provide consultations, and to whom? It was free of charge consultations to individuals who requested them. I studied various requests. I asked to the inquiries of these individuals, provided them with a full scope of information, and thus I satisfied their needs. Do I understand correctly that these consultations were not practical, or they were theoretical only? Yes, they were theoretical only. Yes. All right, thank you. Dear colleagues, the floor goes to you. I've got a question. Good morning. Please tell us an ideal profile of a disciplinary inspector at the SDI. How does it look like for you? I think if there is a distribution amongst the sectors or sections, I think that can you please pick up, and I will repeat the question. For you, the ideal profile of a disciplinary inspector, so what kind of qualities an inspector must have? What kind of criteria he or she should meet? The criterion number one, independence. He should be independent from external factors, from possible pressure from other people. The timely operation, so he needs to be diligent in his work, the unbiased work, so he must be able to make decisions without any likes or dislikes, without any discrimination on the grounds of race or religion or whatever. He certainly must meet the criteria of property integrity and certainly comply with the ethical rules of conduct in the society in an unwavering manner. So these are the criteria that the inspector should meet. Thank you. What kind of advantages do you have compared to other candidates in your view? I am really committed to the work that I do. I'm resistant to any distress, to any factors that may try to influence me. I am unbiased. I'm totally independent on anyone when I make my decisions. I will only base my decisions on my experience, my knowledge, my understanding of the fundamental documents and case law. I think I meet all these criteria, and this is going to be my advantage compared to other candidates. Thank you. What kind of challenges do you believe may you may come across as an inspector at the SDI? Well, the first practical challenge would be the huge amount of work that an inspector would need to perform after appointment. the timely discharge of the duties. That's going to be a challenge to satisfy to ensure the rights of the judge and the complainant within disciplinary proceedings. Also, different profiles of the complaints, different types of violation that judges could have committed, be it a violation of ethical standards or behavioral. We would need to filter them, distinguish those complaints, and make appropriate decisions, because each complaint is going to be unique and will have some specific traits, nature, and the inspector needs to understand that and make decisions fast.
Do you know what is the number of complaints which are under consideration in the High Council of Justice? No, I failed to find this information. That's around 10,000 of cases under consideration of the HCJ, and for now those cases will be transferred to the Service of Disciplinary Inspectors. Please tell us, how could we optimize this process? What filters would you apply to have a more effective process of consideration of cases and the quicker actual consideration of cases? First of all, I would start with complaints which have been at the desk of inspectors for consideration for a long time. Definitely each complaint should be reviewed, but I think that the number of disciplinary inspectors is quite enough and is quite high, and that's why I think that the process of selection could be started, could be initiated, and each inspector should be assigned with a specific number of those complaints, and also we shall identify specific deadlines for for completing those complaints in order to avoid such situation in future with excessive number of complaints. Sorry, but for yourself, how would you identify it for yourself, this order of action? So you received a number of complaints. Which will be your priority complaints? Which will be the next ones? Reviewing all files of disciplinary complaints, I would likely take into consideration those complaints related to judges who will be retired soon, or who are in the last years of their work. I mean, they're almost 65 years old. Very soon they will go to the retirement. This is my first category of cases which I will take into consideration, based on which grounds you differentiate these cases from other complaints. This provision is also envisaged by law that regulates operations and functioning of our inspectors. Thank you. I have such a question. I think it's new to you. Have you had such situations in your life which you could be proud of? Yes, please tell us. First of all, that's to enter the university which I actually wanted to study at. Then that's to pass very hard competition to the State Bureau of Investigation, where I worked since it was establishment in 2018. And also I can say that I have this experience of working in the new authority, in the new body. We also received a huge number of criminal proceedings from investigators and prosecutors' offices. That's we're speaking about some working dimensions and aspects. And so now my work at the National Police, it's quite hard, but I like it personally. These are those things from the perspective of the job. Thank you. That's all from my side. Dear Roman, hello. Good morning. You know, an interview, that's a very good possibility for all commission members to find out more about a candidate. Because, you know, just your dossier, your biography, your points, it's one thing, it's good. But of course, communication gives us better possibility to find out more about you. Please help us with that. Please tell us about your work now. Where do you work? What do you do? What functions do you perform? Now I work as an investigator in the investigation in the police precinct number 1 in the Zhytomyr region. My position is senior investigator, but for more than a year I have been implementing functions of the acting head of investigation. So my functions, direct functions, include to carry out guidance of a pre-trial investigation, and also I carry out pre-trial investigation by myself. I arrange investigative measures to be conducted. I also establish communication with prosecutors' offices, with courts, in order to have quick pre-trial investigation of criminal proceedings, because National Police has under its jurisdiction a lot of articles of the Criminal Code of Ukraine, and it means that we have so many different criminal cases which require our immediate response in terms of investigative measures. So first of all, we need to prioritize to identify what cases should be the first one to consider, then to plan, and planning both in terms of months, 3 months, and 6 months. That's what I'm doing right now when I work temporarily as an acting head of investigation. So you have under your subordination some employees who are you responsible for? Yes, I have 5 investigators and a deputy head. Yes. So you arrange all work, everything what should be done by the head. Yes. Thank you. Clear. Well received. Tell me, please, how do you think? How is this your experience? And you have it's quite big based on your biography. Could be useful at the position of an inspector to compare the work of an investigator and the work of an inspector. You could have so many different analogs. So an investigator should collect information in criminal proceedings the same as an inspector should collect evidences in the disciplinary complaints, in the disciplinary proceedings. And upon agreement with the prosecutor, investigators files these files to court, and the disciplinary inspector should do the same and submit documents to the disciplinary chamber of the High Council of Justice, and also drafts decisions, and the same as prosecutor reports in the court and on the convicting act, convicting ruling, and the same, and the disciplinary inspector is a rapporteur in front of the HCJ regarding this disciplinary complaint. Actually, there are so many different similar things. Okay, thank you, well received. So, yeah, I agree with you. Okay. Tell me, please, what does it mean for you, the category of fairness or justice? So do you mean for disciplinary inspector? No, at large. What is it, a category of justice means for you? For a lawyer. So generally, a lawyer makes some decisions. Either this legal specialist is in the position of an attorney, of a prosecutor, of an inspector, and to my opinion, justice envisages the decision-making process which complies with their own position, and their own position should be based on understanding of legislation, on understanding of the positive law, And those decisions should be made despite of any external factors or despite of any characteristics or features of a person, whether this person lives at, whether it's region, or whether he or she lives within Ukraine, or her or his hobbies such as sports or so on, religious beliefs, so any beliefs, any what he or she likes to do. Such decision of legal specialist should describe the category of justice, to my opinion. More to say, it's fair to make a decision regarding a person who actually maybe deserves some kind of sanction to be applied. And also, it's fair to make a decision regarding a person who doesn't deserve any sanctions applied against her or him. That's my understanding. Thank you. Have you ever experienced unfair situation or lack of justice at work regarding yourself? So, if you have experienced such cases, please tell us about it. You know, the work is things that is done very quickly, and sometimes you need to replace, for example, an investigator in the team of investigators, and it should be done quickly, because this investigator is involved in other investigative measures for another criminal proceedings. And the head reports to me that such person should be replaced right now, but it's more so it's more about justice which was applied to me from his side, but my plans, my timing, my efforts dedicated to investigative measures are annihilated, because there is an order which goes down from the leadership, and I first of all need to fulfill that order, to do that order which was issued to me from the leadership, so to carry out those investigative measures. So do you mean that you have experienced that that's unfair towards you? Such situation which you described in those moments, in those situations, in that situation. But generally, have you ever experienced any other unfair situations regarding other employees at your work? That regarding other employees also such unfair situations happened? Now, our team, we don't have such things. Also, illegal orders are absent, or extra time work. What do you think? At work, fulfilling functions, are there any options to protect yourself from such unfair situations? Of course. For example, let's take some sanctions, a penalty, or for example, to take some premiums or benefits from such an employee. The clear countermeasure could be challenging in the court such decision. For example, if we're speaking about prosecutors' offices, you can apply to specific authority. In each authority, so you can apply to Qualification Disciplinary Commission of Prosecutors. In each prosecutor's office, you have a special unit which is responsible for this. But if such issues are not regulated, okay, for example, a penalty or taking off some premiums, yes, there are, or reprimands, there are somehow already developed mechanisms how to deal with it. But if there are other situations, for example, there are some in your person is insulted by leadership, or everyone goes to abroad business trips and you don't go. There is always a higher level leadership. So it really means that leadership always has better understanding. Yeah, like this. That's how job duties are developed. Thank you. That's all from my side.
I would like to ask you about you explained a little about the mission of, as you see, of this service, also about your motivation, but I would like to ask you to provide some specific motives for moving to this office if you win the competition, so in participating in this competition. Because as I understand from your presentation of your current work and your current capacities, you see meaning in your work, you like it, you feel good and competent in this capacity. So what are your personal motives to go for this position?
Thank you for your question. As a lawyer, as an actual graduator from the law department, so I always say about myself that I'm a lawyer, and I'm a legal specialist, and the highest point of career for a legal specialist is to become a judge. And in order to become a judge, you need to meet some requirements of the legislation, including that to reach the age of 30 years old and 33 years old. And when I'm 33 years old, I already plan to be a judge. That's an example. But as there are no announced competitions as of now, I would like to be closer to the system, and that's why such work as the role of a disciplinary inspector at the SDI, it will be one more step to make me closer to my personal dream to become a judge. This is the first aspect. The second aspect, at this body, the salary is high, and this services body also has enough budget funds to establish some organizational issues at work, and it means there will be no problems with arranging all technical issues, equipment, and to have access to normative base and so on. That's why I decided to meet this challenge and applied for the position of disciplinary inspector.
I do appreciate your honest answer and regarding the remuneration, which is, of course, very important component in our decisions in our career. And it's just curiosity. I'm curious, usually the usual career to judicial office, it's becoming an assistant of a judge, not necessarily, but it's a very usual practice. Didn't you consider this opportunity to work in court and to see this organization of courts of activity, court proceedings from inside the court before applying for a judge?
Thank you for a question. Yeah, I've considered this option some time ago when I graduated from the education facility, but it happened that in 2018 there was a competition announced for the State Bureau of Investigation, and respectively I made a decision that at that time to apply for that competition. And if we compare the work of an investigator and the work of an assistant, of judge assistant, for for the sake of your future, possible future appointment at the position of a judge. There are advantages in both of those positions, because a judge assistant quite often could be a judge assistant, an assistant to a judge of one specialization, for example, civil law or commercial law, and then he or she will not understand anything how actually it goes in criminal justice, and will not understand some elements of crime, of a criminal crime, envisaged by the criminal code of Ukraine. And that's why these are two, such baselines. I mean, the position of an investigator and the position of an assistant, which we are talking about right now, which comprise a very valuable experience for a position of a judge.
To ask one more question from a bit of a different nature about the grounds for judicial the liability of judges. In your opinion, does any breach or infringement of ethical rules and principles of judicial ethics, I mean, constitute the ground for the liability, disciplinary liability?
I believe that not every violation is a reason to bring to disciplinary sanction. A judge may make a mistake, or actions of a judge may look for an external observer as such that violate some ethical standards or moral principles. So it's a subjective understanding of anyone. A subjective understanding of any person regarding certain actions of a judge and the disciplinary inspector when analyzing case files about such a violation must make a decision that would be objective, honest, fair, without any subjective attitude towards the actions of a judge.
You mentioned this is kind of a matter of subjective evaluation of one or another behavior or an action of the judge. On the other hand, as you say, inspector has to make a decision and conclusion which would be grounded and objective. So how would you determine, what are the main criteria that you would encounter in deciding if this particular action constitutes the ground for disciplinary liability? What would be like 2 or 3 main criteria? How would you determine?
I will take into account the criteria of integrity or of judicial behavior, the Bangalore principles, as well that he or she violated in his decisions. I will take into account the Code of Judicial Ethics, and this is the document that I will take into account to decide on a particular situation.
Thank you. And give a floor to you, please.
Добрий ранок. On your resume, you indicated that you worked for JSC Legal Alliance as general counsel. What is this position?
I worked as a general counsel. This is a law firm that provided services to different clients, mostly corporate clients and private individuals. My functions included drafting claims, systematizing reports regarding regarding the judges with whom the lawyers worked in this the law firm. If I remember correctly, I worked there for about 4 months or something. I also attended court sessions, so we were kind of assistant to a defense lawyer, not more than that.
I did note that you were there for 4 months, and it looks as though you kind of went to a lot of jobs in your relatively short career. So you started off in this committee for combating corruption, then went to JSC Alliance, Legal Alliance, and then you were in an investigative department for 20 months. Then you looked like you went to SBI in Lviv for 8 months. Then you returned to the Committee for Combating Corruption for 9 months, and then back to Investigation Department for 4 months, and then you went to another position with that National Police for 5 months. Can you explain why you took these positions for such short periods of time?
The reason, I mean, the first job was obviously after the university. It was not paid for, but to be paid, to get the salary, I got this job with the Legal Alliance, with this law firm. Then there was an open competition for a position of investigator in the SBI in Khmelnytsky. Then I was transferred to the SBI in Lviv. Then I became an investigator in the National Police, and also it was based on an open competition. I also was an operative because of the change of the organizational structure. So I changed my job profile from investigative into operative. And then I was appointed to the position of senior investigator. It was a vacancy that we had in our division, and now on this position I work. I'm an acting head, but I didn't specify it in the resume because it is not included into my employment record book.
Do you think that there is, at this time in Ukraine, public distrust or skepticism about the judiciary?
I will analyze and I will express not my personal attitude to the court, of course, because I worked with courts only as an instigator. So I can't say anything skeptical about the court, the judiciary in general. Yes, there is a public opinion, some skepticism towards the judges and the decision that they pass. But to be able to say something about that, I think you need to be in some way involved into the proceedings, court proceedings, and it's only the parties to those proceedings that have the right to express some dissatisfaction. I can't objectively evaluate the public opinion that dominates today in Ukraine because I didn't come across courts as such, or court hearings. There were no negative decisions made against me, and I never saw any judge behaving in some undignified way, except for the media.
Perhaps when you said except for the media, but my question is really, do you have any understanding about the public's perception of the judiciary? Either through the media or just general knowledge about how does the public perceive the judiciary in Ukraine? And is there distrust of the judiciary?
Well, I can analyze only the people whom I work to in my area of work, and I haven't heard any well, comments or remarks as to the judiciary in Ukraine. For us investigators, it's important to file a motion, certainly, and sometimes in one court you can do that during the whole work day. In other courts you can do it only in the morning, for example, but that depends. But if you talk about the general public opinion, well, the general public has the total right to express their position, and I don't have the right to judge it. But given the patterns, the trends that we see today, I think the public trust to the judiciary has grown a lot. For example, the court hearings are being covered today, hearings or sessions of the Constitutional Court or the Supreme Court. They are covered now in media, online. Or this particular competition, it has been carried out online. A lot of viewers can watch it. They see what kind of questions are asked, how professional competencies are assessed, and these small steps gradually strengthen the trust to the judiciary.
Thank you. I will defer to my colleague, Mr. Zelinchik. Thank you.
And thank you very much, Madam. All my questions were already answered, so I passed the time. Thank you.
So please go on with the final stage.
Ні, тоді переходимо.
Indeed, let's move on to the final block of questions. Yulia asked you about any action that you can be proud of in your life. Have you ever committed any actions that you feel sorry about? Well, of course, life is not ideal, and sometimes I wish I could have done something different, but there were no such anything big in my life that I feel sorry about. Well, I'll give you a situation. Let's say you receive a disciplinary complaint against a judge who was pulled over by police and prepared a report on him violating the traffic rules. In particular, he was driving under substance. What do you do as an inspector? Do you believe that judge should be subjected to disciplinary responsibility, and if yes, which one? As an inspector, I will certainly wait until there is a decision on the case regarding bringing to responsibility, court decision. If the decision is not available, the fact happened, but the deadline's passed, then I can ask for the case files. Because I don't want to interfere with the judge. Let's say we have a court decision. The decision closed the proceedings because of the statute of limitations expired. But the inspector receives a disciplinary complaint from a civil society organization, let's say, which alleges that there was that case. Please bring this judge to disciplinary responsibility. When you analyze the files, and if the deadline's passed, and when you read the operational part of the judgment and motivational part, I probably would bring the judge to disciplinary sanction. But we need to take into account whether it was the first time for him or not, whether disciplinary sanction has already been applied to him. But each case is individual. You say, I would make decision, I would apply. Yes, I would transfer that decision to the ACJ for consideration. Would you transfer what? A draft decision. Okay? You probably understand why I've been asking these questions. Let's discuss the administrative case that was considered against you in the Haritsky District Court in Lviv. You probably know about the case. We asked you about it. Please tell us what was the case about, what was the decision. Did you agree with the decision? It was 2017. The vehicle was pulled over. I was driving the vehicle for failing to switch on the when I was trying to move to another lane, I didn't show the indicator that I was trying to do that, and they pulled me over and they offered me to be analyzed with a breathalyzer. They didn't explain to you the circumstances. They never said anything. Why? No, they didn't. I didn't understand their motives and I refused. Then the case files were transferred to court. I wasn't informed about that. I couldn't make my case there. You mean you were not informed by the court? Were you subpoenaed? Well, the subpoenas were sent to the address, but I wasn't living at the address because I was studying back then in Poland. And I called to the secretariat of the court, and they told me, yeah, we would call you and you'll be duly informed. But I wasn't called, so I couldn't file any challenge, any appeal. Okay, so they have offered you to be analyzed in terms of the use of substance at the scene, and you refused. So initially you refused to be examined with a breathalyzer at the scene, correct? Well, they didn't explain anything about the equipment, device, and they just said, please, let's do the analysis. But in your explanations, you said something else. Why you refused? They offered you to be examined with a dragger. Yes, but not in a hospital, not a medical institution. Now tell us, were you driving under substance? No, I wasn't. But you agreed with the court decision. You never challenged it. I did in the Court of Appeal. So what was the result? The Court of Appeal decided to cancel the decision of the court of the first instance and to pass the decision to review of a civil society organization called Initiative of the People. What kind of organization is that? How are you connected with it? Well, as we were members of the organization when we were students, because this is a student organization. So you say when the court passed the decision, you were in Poland. So until 2017, you had such close decisions with the organization that the court decided to hand over the case to the... Yes, I had close relations with it, close connection with it, because we, as students, we were members of the organization. How did this organization learn that that kind of case was heard in court? I informed them. So you approached the organization. Yes, certainly I informed them about it. And they decided that you should not be brought to responsibility, and so that the Court of Appeal would transfer the case back to them. Yeah, they just talked to me for preventative purposes. Where exactly? You were back in Ukraine by then? Yes, I was. It was November, I guess. Another question about the cash savings you've got. Your declarations, you indicated on your official salary as a source of income. The income is not that high, but still you have huge savings in US dollars and euro and national Ukrainian currency. What is the source of this? It's a salary. I don't have a family, I'm not married, I don't have children. And the salary, mostly I spent my salary to buy currency.
Thank you. So, yes, Member John Erling wants
Could
to
I
ask
just
one
get
question. Yes.
could I just get a clarification? In 2017, you were attending National University in Lviv, but were you living in Poland?
No. I graduated from the University in Lviv in 2015, and from 2015 until 2017, I studied.
If you were studying for your master's degree in 2017, where were you living?
І в Польщі, і у Львові.
Both in Poland and Lviv.
З 2010
From 2010, 2015 until 2015, June, and from October 2015 until November 2017, I studied in Poland, and before 2015, I studied in Lviv.
Thank you. So the part of questions is over. So now you have a time for final remark or comment. Please.
Thank you for your questions that the distinguished commissioners asked. If I win in this competition for the position of a disciplinary inspector, I will take the utmost effort to be effective in this position, to ensure the principles of the rule of law in the first line, the fundamental human rights, the respect to people, to respect to human rights, to respect to the institution as such, and to ensure the trust to the HCJ. I think that my experience of work experience in the investigative authorities is important and valuable for the position of the disciplinary inspector in the SDI. Thank you.
Competition and participation in this interview. Our decision on the winners of the competition will be made after all interviews will be finished. So interviews last until next Friday. So after that, in several days, we will issue our decision, and of course, you will be informed about it. So thank you very much and good luck.
дуже дякую за увагу.
Thank you for your attention.
Добрий ранок, пан Олександр.
Good morning, dear Alexandra.
Today we are going to conduct the interview for the position of the disciplinary inspector, and we have candidate Alexander Sukhomlin. So first of all, I would like to inform you that the interview will be conducted by the selection commission, which is the entire composition. I'm Reda Moliene, the chair of the commission, and also we have members of the commission: Yulia Bokova, Olena Kovbi, Olga Popikova, John Ehrlich, and Pavel Zelinchik. Do you have any requests regarding the composition of the commission members?
No, I don't have.
So the interview will last for about 1 hour, and we will ask you some questions about your professional experiences, background, competences, and also understanding of judicial ethics and integrity. And at the end of the interview, you will have several minutes for your final remarks and comments. You are kindly asked to be as concise as possible in your answers, because we want to have an interview effective and complete during this time. So the technical aspect of the interview, that it is broadcasted, probably you know this, and please be informed that if there is some kind of information which falls under restrictions for public disclosure under the martial law, please inform the commission, and some parts of the interview could be held not in public. If you do not have any questions so far, so we could start the interview with your introduction, presentation of your background shortly, and motivation, and your understanding of this service and its mission. Thank you.
Good morning again, dear Commission members. I will be as much precise as possible. First of all, I would like to mention that independence of the judiciary is an integral element of the democratic state and its value, which actually fosters the rule of law principle and also application of the fundamental freedoms and rights. It also should not be considered as some kind of privilege, but these are guarantees to ensure impartial, independent and fair judicial proceedings. And actually it's also envisaged by the Convention on Protection of the Fundamental Rights and Freedoms. And European Court on Human Rights has been gradually implemented such model through which the authority which actually considers complaints regarding some representatives of legal professions and acts as a court. In this case, in Ukraine, that's the High Council of Justice. If it takes as a model, as a baseline, I mean this authority to be to fulfill such functions. So to combine functions of consideration of disciplinary complaints with investigation of disciplinary complaints against judges, that's not something strange for a court. That's why, in order to differentiate those functions and de facto to investigate disciplinary complaints, that's why establishing of the Service of Disciplinary Inspectors has been decided, and this service goal is to help the HCJ to implement its functions in the process of the disciplinary proceedings against judges. Here we need to mention that this body is a standing alone body, and it's based on the principle of the functional independence. It means that it's independent in terms of responsibility for their power, for its powers, and bears responsibility for such decisions. And no other body could intervene into the functions and activities of such service. And also we need to mention a role of disciplinary inspector here. It would be mistaken saying that a disciplinary inspector should perform a role of prosecutor in this process, but we can't also say that his or her role is passive. No, it's rather active, because an inspector has such duties to decide whether consider or return a complaint, and also he or she has duties and responsibilities what to do, for example, if they do not agree with the decisions of the HJ and whether to initiate disciplinary proceedings upon their discretion. They could submit actually such case to the HCJ. He's also a member of the disciplinary proceedings. That's why SDI, an inspector has rights of a participant of such disciplinary proceedings. And regarding my experience, I've been working for 10 years in the judiciary, and I have gained already those skills and competence which, to my opinion, fully comply with disciplinary inspector's role. And to this, during this time of my work at the judiciary, I have gained those knowledge, skills and competence which fully correspond to the powers and duties of a disciplinary inspector. In particular, to work at the judiciary constantly has significant working loads and necessity to work with huge amounts of files and with high number of cases. This experience will help me at the position of a disciplinary inspector to work effectively and consider that high number of cases which are right now under consideration of the High Council of Justice. Also, when I worked as an assistant to judge, I dealt directly with preparation for trial hearing of cases and preparing and drafting court decisions and taking into consideration work, my specific work at my authority. So the level of quality of my text which I prepare is very high. They should be of high quality. Also, it will help me, this experience will help me to draft quality decisions for the and quality opinions for the disciplinary chamber of the HTJ, because working at my role right now, I understand how important it is to so how it's important to comply with constant rules of implementation of judiciary practice. And my work is related to all these different spheres. That's why I think that my skills, my competence will help me to fulfill effectively the role of a disciplinary inspector and its duties, and as a result it will help to increase the level of trust towards the judiciary.
Now I would like to give the floor to Commission member Yulia Bokova to start our session of questions, and we will start from questions about your professional background and competences and your insights about some aspects of judicial ethics and discipline. Thank you.
Thank you.
Вітаю вас, пане Олександре.
Greetings,
Вітаю з доходженням до
Alexander, and I welcome you here that you reached the final stage of our competition, the interview stage, for the position of a disciplinary inspector in the Service of Disciplinary Inspectors. And I have a range of questions to you. So tell me, please,
для вас має бути
what
інспектор? Якими якостями
what do you see a disciplinary inspector? How do you see it? What should be the qualities of a disciplinary inspector, to your opinion? To my opinion, a disciplinary inspector should be an example of professionalism and competence. He or she should have high moral and ethical qualities and comply with all requirements for civil servants. Tell me, please, what qualities will you use at the role of a disciplinary inspector? I mean, your personal qualities: professionalism, competence, independence, impartiality, objectivity, and those moral and ethical qualities that I have. Tell me, please,
мета створення
what is the goal? Can you please dwell upon the goal of establishing of the Service of Disciplinary Inspectors, to your opinion, under the High Council of Justice? What is the purpose of it? As I've mentioned already, as a body which conducts, which fulfills as a court, and actually for such authority, it's not standard, to combine such functions as consideration of complaints and investigation of complaints. And HCJ actually has other duties and other functions should be performed according to the law. That's why such functions should be transferred to the Service of Disciplinary Inspectors, which will help to have to carry out this work more efficiently, and also will allocate more time for the HCJ to consider specifically disciplinary complaints. In no case I would like to say that the HCJ is ineffective in fulfilling this function, but it's obvious that if a separate authority is established, it will help to eliminate some kind of some part of workload from the HCJ, and will help to have it more efficient in consideration of complaints. Thank you. Do you know what is the number of disciplinary complaints complaints under consideration of the HTJ right now. As far as I know, around 10,000 complaints are non-considered as of now. Yes, and when the Service of Disciplinary Inspectors is established, this huge number of disciplinary complaints is transferred specifically to consideration of the service. So tell me please, what will be your first steps? For example, you receive 500 complaints.
Чи будете ви визначати пріоритетні?
Will you prioritize them?
Як ви буде здійснюватися
How
оптимізацію
will you
діяльності
optimize your work in order to do it in the most efficient and quick way? So in any way, even the law on the High Council of Justice envisages some priority categories for disciplinary complaints that should be considered first. I don't know how the automatic system of distribution of cases works in the HTJ, but for example, when the disciplinary complaint is transferred to an inspector, whether it's a prioritized case or not. If there is such a mark that such case should be prioritized, then you need just to look what cases are prioritized by the HCJ and you consider them first and you take them into your consideration. But if there is no such technical possibility, then the whole volume of disciplinary complaints, first of all, should be reviewed in order to identify what are the grounds for prioritization of this or that complaint, and then all those complaints will be considered one by one as envisaged by the law. Thank you. Tell me please, what are the challenges that you see for yourself
перед собою у випадку зайняття даної
if you have this role of a disciplinary inspector?
I think the major challenge is going to be this huge amount of disciplinary complaints that need to be reviewed within the deadline set out in the legislation. We need to be really efficient here and meet the expectations that are there for the SDI. I can't give you all the details, but I believe that I have necessary skills and knowledge to address the whole amount of the complaints. Okay, you've been working for quite a while in the judiciary as an assistant judge in particular. If you are appointed to the position of the inspector, let's say you receive a complaint against a judge with whom you have worked with, what are going to be your actions? I think that when the SDI becomes operational, there will be already regulations on the SDI already developed, and there will be understanding how you can self-recuse if you are an inspector, and if there is a complaint against a judge with whom I work, I will have to recuse myself. Then the next question. Do you think there are risks, corruption-related risks possible? Are there any possible risks on the position of the disciplinary inspector? If yes, which ones? I think the corruption-related risk can happen in any public institution. For example, there might be potential or actual conflict of interest, but there is the legislation on the prevention of corruption that sets forth the clear range of actions, sequence of action that a person must take if there is a potential or actual conflict of interest, and there is also a chance to refer to the NACP if you have any doubts about the potential or actual conflict of interest. So you mean if there is some external pressure that someone tries to exert on you, you're going to be acting just like that? Yes, but much will depend on the nature of this pressure. If it will have signs of administrative or criminal nature, then I'm expected to inform the law enforcement agency about that. But if we talk about the potential actual conflict of interest, I must behave in line with the law on the prevention of corruption in Ukraine. In your work as an assistant judge in the judiciary, have you ever come across any ethical dilemmas? I have not had any ethical dilemmas, But just like any person and a legal professional, I have my understanding of the fairness of law. And if if I had any idea that a particular law is not in line with the rule of law or in line with the principles of fairness and justice, but still, as a public official, for me, my public official duties are higher than my personal views. So that's my answer to your question. Why did you decide to apply for the SDI? You've been working in the Supreme Court for some time now. Why did you decide to change something? I think I have gained the knowledge, skills and aptitudes that would help me to contribute more to the development of the state and the rule of law in the state, in the country where I'm going to live. Since I'm working in this area, and I want to remain in the judiciary, and I want to contribute to the development of our country. Thank you. What do you think? Does any violation of the judicial ethics require dismissal of a judge from the position? No, because the Article 106 of the law on the judiciary and the status of judges says that the grounds for dismissal of judges is the violation of ethical conduct that is incompatible with the position of a judge. So it doesn't kind of explain what amounts to this behavior, but some really blatant cases should lead to the sanctions. For example, if the person was driving under substance and committed traffic violation that led to severe bodily harm or even death of a person, then in any case this is a violation of the ethical standards that is not compatible with the role of a judge. In your view, is this norm sufficiently regulated in the legislation or not? I think it is not clearly determined, clearly defined, but given the huge possible types of situations or violations of that kind of norms, you need to assess all the circumstances of each case so that we don't kind of limit the ACJ in its need to bring a judge to responsibility if this judge indeed committed a violation. I have no more questions. Please ask yours, dear colleagues. Thank you, Alexander. Good morning. I've got the following question. Since 2013, you received the higher education diploma, and then several months later you were appointed to the first position, kind of high position. How did you manage that? Did you have any experience before that, or you were just appointed right away as an assistant judge? Yes, I took an internship in this court. I was sent from my university, and I took the internship twice in this court, and I knew how the court worked. I gained some knowledge. When they were looking for an assistant judge, they analyzed myself as a candidate for the position. I prepared draft court decisions following the request of the judge. She liked those drafts and the quality of so she decided to appoint me as an assistant judge. Who did offer you as a candidate to apply? I think the head of the secretariat. You don't know about it, right? So you know only that you didn't apply personally. No, I didn't apply personally. No, I took internship there for some time, and I said I would love to continue working there. So once there was an opportunity, and you appointed to the position on the judge where you took the internship, or was it another judge? Well, I took the internship in the High Commercial Court of Ukraine, and I continued working there after. No, you said you took the internship twice with two different judges. No, yeah, I took the internship not with a judge whom assistant, the assistant of which I became. I just had the internship in the High Commercial Court twice. 6 months on the first year and then 6 months in the next year. So once I gained some knowledge and worked there, they appointed me. Another question, when you were answering Yulia's question, you talked about a disciplinary complaint against a judge who drove under substance and committed harm to someone. What if he didn't commit any harm, but he was pulled over, there was a report prepared against him? Should this judge be dismissed for that kind of action? Well, I believe that this is also a violation of ethical norms that leads to dismissal, because a judge must never commit such a violation as driving under substance. Thank you, colleagues. That's it on my end. Good morning. Alexander, let's think about the regulations on the SDI. Because the HCJ is drafting the document now, we understand how important these regulations are, and you know the legislation very well, and you are demonstrating it right now, but you probably understand that there are big gaps that the regulations can address. In your view, what should we have in the regulation on the SDI? Just give us a basic understanding. What important factors need to be set forth in the regulation to start for the SDI to start working effectively? Well, the regulations on the SDI must explain its status and authorities that are explained in the law on the HCJ, the right for self-recusal, and the description when it this tool can be applied. The mechanism for interaction with other structural units of the HCJ must be explained there as well. And we would need probably to read regulations on other structural units of the HCJ. Maybe some of the clauses need to be included into regulation as well. But SDI is going to be a kind of independent structural unit, and maybe there are other units as well, and we can include some of the clauses from their regulations into the regulation of the SDI by the analogy. Do you think the matters of priority of consideration of disciplinary cases have been regulated successfully enough, if I may use this word? Or do we need to duplicate something, or do we need to prepare something else? I think if we talk about priority of consideration of disciplinary cases, and I understand these are related to the request of the HQCJ or related to the transfers of judges from one court to another. Or yes, they include some dismissal of judges, that kind of cases, or they provoke some public outcry. I think we would need to include into the list of priorities the complaints against judges who filed resignation letters. But I don't see any other issue that may require priority attention. Okay. when the self-recusal of a judge may lead to may be a ground for disciplinary responsibility, and in fact, can a self-recusal of a judge be a ground for disciplinary sanction? I think that self-recusal can be a ground for disciplinary sanction when there were evident no reasons for self-recusal of a judge, but if a judge wanted to avoid hearing of some case or really complex case or some notorious case, the judge doesn't want to hear the case and wants to give the case to another judge. So indeed, if we see that there is no reason for self-recusal, but it happened, I think in this case it may indicate that there are some grounds for the disciplinary responsibility. So it's kind of avoiding the administration of justice. Is that correct? Yes. Do you know, has there ever been any case law, disciplinary case law on that kind of cases within the HCJ? I think that when I was preparing for the competition, I found these cases, but I can't give you references to the particular year when the decision was made, but I saw it happened. Can we imagine that disciplinary inspectors also can abuse their right for self-recusal to avoid consideration of a particular really complex or really notorious case? And what do we do about that? Yes, I think it is possible, because there may be people who don't want to be effective in the discharge of their duties, or maybe there is a huge caseload and their case is really complex and they may resort to that kind of action. What do we do? There is a law on the ACJ that gives the opportunity to bring them to disciplinary liability, and I think we must consider these cases as well, because it may indicate that the disciplinary inspector committed a violation in this case. And then the next question. Quite a few candidates who are coming to the interviews say that one of their motivation they say that the motivation behind the establishment of the SDI is to help the HCJ, and I kind of start feeling sort of helpless here, so to say. So please tell us, what was the actual aim of the legislator to establish this service? Because if we thought only about addressing the issue of the caseload at the HCJ, then we could easily just hire just a couple of more specialists with the HCJ. So why would you establish this new institution? Why would you carry out such a complex competition to find good experts for that? As I said in my intro, I think we need to apply the model introduced by the European Court of Human Rights. And since the HCJ, when it considers cases regarding the disciplinary responsibility of judges, it acts now as a court. So now they are doing the consideration of cases, collection information, collection of evidence, and for that kind of combination, I think is quite unusual. That's why I think the delineation of the functions is the basis for the establishment of the SDI. And the last question. I certainly highly appreciate the experience of people who have the experience as assistant judges in courts. I have subjective opinion here because I also worked on this position as well. I think it was really valuable. But you have been an assistant judge for so much time. Can you possibly work independently? Do you feel you have strength to be independent, to stand your point? Because I don't know how the work in your court is organized? Can you defend your legal positions? Can you do it successfully? And do you feel you really have this power, to the strength? If you are selected to the position of the inspector, can you be an independent and autonomous person? Well, along with the positions of the assistant judge, I also worked as a chief specialist, and I independently discharged the functions and job duties. And I think it, it doesn't affect my ability to work independently, because when I work with the judge, I provide him the information that I could find. I explain my viewpoint as much as I can based on my professional aptitudes, but it is the judges who make their decisions. And the more and the better information I can provide, the more it contributes to better decision making. I would clarify one thing here. If you believe that in terms of your professional skills and based on your background, you prepared a draft decision, but the judge disagrees with it, and you can't persuade him, or can you? What do you do next? Well, the judge doesn't discuss with me the decision that he is gonna pass. Okay, you prepare a draft, to deny a motion, and the judge gives it to you back and says, no, let's cassate it. So do you just go and follow the instruction, or do you try to defend your stance? Well, to understand what I need to write in the decision, and if my opinion differs from the opinion of the judge, although it sounds really weird that my understanding of an assistant judge kind of differs, because the judge has more competence, and the judge tells me what I need to write down, and but he can't explain to me how the decisions are made in the deliberations room, because there is a secrecy of the deliberation room. So yeah, he just explains to me what I need to write down in the project, in the draft. Thank you very much. Good.
Have less them, but still, I would like to ask you to tell us about the most challenging critical situation in your career, in any of those institutions, and what, because I suppose everybody has some situations that we remember for a long time. And how did you deal with this critical situation?
I think the most challenging situation over my career was what happened when some of the people who worked with me, my colleagues, they couldn't work because of being on a sick leave and because of other reasons, and I needed to work fast. That's why I had to take over some of their job, and under such a huge caseload, that affected obviously me and my work, but I don't have any time limitations. If I need to stay over, I do, because I needed to. If I need to discharge all the tasks that have been said to me, and the criticality of the work was the fact that I had all these cases that I had to deal with, but I managed to do it.
And coming back a little to previous question, have you had any situation when you did believe that this should be the true or the right decision, or this kind of the protection of human rights should be in place, and somehow the opinion of judges were not the same. So was this kind of the situation in your life?
No, I didn't have such situations, as in a major part of the cases, maybe 98%, my opinion, my vision also correlates with vision of judges. But if I think that, for example, that some case should be considered in a different way as a result, but I'm only the judge assistant, but the judge has their powers to make decisions, they have more experience, they have a more longer career path. That's why even in those cases when the decision was different in comparison with the draft ruling that I prepared, taking consideration that I need to write down what judge tells me, I saw that logics and I saw no violations in those cases.
You are happy and lucky person, I think, because, well, I did have this kind of situations in my career as judicial assistant, but that's good. So I would like to ask the last question that I have. We discussed with other candidates as well, and it's like public discussion about the public trust in courts, in judiciary in Ukraine, that, well, this trust is not very high, so to say, and well, it's sometimes increasing a little. So what reasons are behind this low public trust? And in your opinion, what 3 or 2 like actions or initiatives or some other things would help to increase this public trust?
You know, any person who gets the status of a judge, together with this respectable status, gets high responsibility, and he or she needs constantly to develop their professional and competence level and to be a high example of complying with moral and ethical norms. This person should both know ideally perfectly rules and also be an ideal example of behavior, and those specific feature qualities, when you know people look at the behavior of judges, it allows them to feel confident that yes, indeed, their cases will be considered by a professional, fair, independent, impartial court, and in any case, it doesn't matter how much work is done, and it doesn't matter how many disciplinary violations are prevented, but one violation could stop, could cross all that good, professional, duly done work. That's why I think that this principle of that the disciplinary punishment is unavoidable for a judge if he or she indeed committed a disciplinary offense, is in all cases shows that abuse of judges is not left without attention, and such judges will be brought to responsibility.
Good morning. I will start with this question. You said that you have never faced ethical dilemma in your professional life, which, if I count well, it's about 10 years, maybe?
I noticed that as a legal person, sometimes I didn't see that laws are fair and indeed ensure the rule of law, but the law is law and you need to apply it in those cases that we have.
Thank you very much. And now I get to the very point. How would you define ethical dilemma? What is it?
An ethical dilemma may be that some kind of discrepancy between principles that a person has with a vision of what the law envisages in terms of other behavioral rules or with other norms which differentiate from understanding of a person regarding the rule of law and equality, if I understood your question well.
I think we need to continue this discussion. Ethical dilemma usually is defined as a situation where a person faces a choice between two or more conflicting moral principles or values, and no option clearly outweighs the others. So it's not only about what the law says, whether the law is just or not, it's much more broad. And have you ever faced a situation in your professional or personal life where you faced a choice between two or more conflicting moral principles or values, and no option clearly outweighed the others?
I didn't have such ethical dilemmas in my experience. As I mentioned, when I fulfill my professional duties, I follow not only my internal beliefs, but also principles of the priority of the interest of the public service.
Understand that you follow them, but that's already the step on the crossroad. You took the right step in the right direction. But for me, it's unimaginable that you didn't even see the crossroad, that there were two options which could be equally, or which could put you into situation, oh, I have these two options, I choose the right one, but I see that I have these two options. Do you understand me?
Yes, but the specifics of my work did not envisage such things, because I don't make my decisions by my own.
Okay. For example, ethical dilemma is also when a colleague or a superior talks to a judge about a particular case. And now, on a scale, this conversation can go from very innocent and clean, all the way to some kind of indication of an interest of that colleague in that case. For example, you are a judge, judges talk about cases, right? They are bound by confidentiality, but we all know that it's not absolute, and it's okay if judges express opinion on legal aspect of a case. But let's face the truth today, often it goes beyond. And judges talk also about or in a form which leads to an attempt that the colleague or another judge, or the communication can come from the head of the court towards the judge, or even to assistant. You know what? I think that in this case, maybe we should consider, and so on, and so on, and so on, leading to more or less clear attempt to influence. Maybe in a good will even, as a good advice to a younger colleague. Nothing like that ever crossed your professional life?
I can be sure to say that I didn't have such situations. I have never been a witness of such situations. But of course, as a judge assistant, I needed to discuss some circumstances with other persons because of the complexity of those cases, and maybe in such conversations I heard the opinion of other colleagues, and if their opinion is different from my opinion, I thought only from the positive dimension, because when I know a contradictory opinion, I know other opinions, I could deliver the most reasonable opinion from my side to a judge of that specific situation. But in my professional station, I have never had had such a case, such situation, which could become a sign of potential corruptional risk of attempt to influence on decision made by judge. Especially when, for example, I report to the judge about the case, I do not discuss with him or her how we are going to solve this case. My task is to prepare a draft and to prepare the whole normative base for a judge, specifically for a judge, to make their own decision rather than to discuss with me whether this decision is right or not. No, that's, you know, that's the task of a judge in a deliberation room to make this decision.
Let's go on. Ethical dilemma is also a situation where, for example, judge is bound by restraint in his public comments with regard to, for example, political situation. At the same time, judge is a citizen, and sometimes, for example, some judges don't have Facebook, some judges do have Facebook, and sometimes judge simply wants to say something. The rule of law in our country is going to be destroyed if this and this law will be passed. He cares about the country. He wants to say something because he feels that he is obliged to speak up if injustice is going on. But on the other hand, he is bound by restraint. But as I said, he is a citizen. He wants to say something to help the country. In this sense of ethical dilemma, do you understand what I'm getting to?
This specific, what you mentioned, yeah, I understand it, but whether I had it in my professional life, no, I didn't have. I didn't have.
That's okay. But on that level of dilemma, it's not about whether the law is just or not, or whether somebody tried to influence you, but on this level of conflict between two legitimate goals, restraint, speak up, nothing like that happened ever to you. Two legitimate interests crossing.
In my work, I didn't have such cases, such situations, because my judge has very high moral and ethical values. I didn't have such things. I didn't experience, but of course, I can't exclude that such situations happen in the judiciary system. But here you shall also take into consideration the status of judges and the restrictions regarding judges to express their public opinion on this or that matter, or in their vision of this or that matter.
The fact that also the international standards allow judges to speak up also on political issues when these are concerned about protection of judiciary and its independence. It's an interesting dilemma, but that's for another time. I will conclude with another question. You said that, and I liked your answer, that the reason for creating Service of Disciplinary Inspector is, among other things, also that the model which is currently in place may be unusual or not fully compliant with the European Court of Human Rights standards. It considers cases and acts as a court, and that is quite unusual. Can we be please more specific? What exactly is unusual in the whole disciplinary process conducted currently at HCJ?
For me, take into consideration this model, which is being implemented by the European Court on Human Rights. For me, it's not standard that the court actually should collect information regarding some specific elements or signs of a disciplinary offense committed by a judge, and the court should fulfill those functions of an investigator, of an investigation of this disciplinary complaint, disciplinary case. I think here there should be a process applied which is currently exists in our law, that the court actually decides analyze the complaint, considers the evidence submitted, the testimony submitted, but independently the court does not decide that I need to look for this information to find this person or that in person, but because in this case we could say that maybe there is even a presence of some kind partiality or biased attitude, that I need to find this evidence, maybe this evidence will speak about this or about that, or something like this, you know? Or anyway, as even a disciplinary proceedings is carried out based on the competition principles, competition basis, we should be sure that the transfer of this function to the High Council of Justice could maybe not correspond to this principle in 100%.
Thank you very much for now.
Добрий ранок.
Good morning.
I just have a few follow-up questions to my colleagues' questions. You've been involved with the courts for approximately 10 years now. Have you ever observed anything that you would consider to be questionably ethical behavior or unethical behavior?
Whether I was a witness of such situation, or what do you ask?
Yes. Have you ever seen a judge or a staff member behave in a manner that you believe was unethical or at least questionably unethical?
I don't remember, I can't recall in my memory such cases right now, because again, during my work, major part of my work is dedicated to my work at the desk, at the office, when I analyze information, so collect information. That's why I work with a specific circle of my colleagues. They are highly professional, and they never violated such ethical norms in my presence. I can't exclude such situations, but I was never a direct witness of them.
Have you ever heard from someone else about someone in your office engaging in unethical behavior?
No. In my office specifically, no.
What about outside your office? Have you heard of people outside of your office engaging in unethical behavior?
You know, I'm not that involved in this information flow. I don't have this information, I don't collect this information, and they don't tell me. I don't have even time for it to listen about such things. Even that's the Constitutional Court, and they have we have a lot of workload. I need to do my work. I don't have this time for gossips, what anyone has done or not. I can't say that I have heard something like this.
Do you have aspirations of becoming a judge?
For now, at this stage of my life, no. I don't have this aspiration to become a judge, and I would like to try myself in some other roles in the judiciary.
Have you been watching our proceedings of interviewing other candidates?
Yes, I watched.
You referenced the rule of law. What is your understanding of what is the rule of law?
I think that the best definition for it is given by the Constitutional Court of Ukraine. As I mentioned, the rule of law is actually the prevalence of the rule of law in society, and in this regard, the law is considered not only as just accumulation of some legislative norms which regulate some relations, but also it's considered as application of principles of freedom, justice, and equality. And I think that compliance with those rules envisages actually and guarantees application of rule of law in the state.
Do you think that consistency is one of the elements of the rule of law?
The legal certainty, I'd say that is one of the elements of the rule of law, and the consistency in the enforcement of law, application of law. Yeah, that comes together with the certainty and gives the chance to the claimants and defendants to understand what kind of requirements are set to them and how the relevant decisions are going to be considered and how the particular legal matter is going to be addressed, if I understand you correctly.
I did understand my question, and my next question is, how do you think that principle would apply to your work as a disciplinary inspector at SDI?
Well, this principle will be about unwavering observance of the legislative standards, norms, application of the observation of the law and abiding by the law, and it will be also manifested in the behavior of the inspector, because he's also part of the judiciary system, and there will be the same values that he's expected to have, just like a judge. So he needs to be a professional in the area of law, and he should be the role model in terms of his behavior.
I think more specifically my question is, how would you apply the principle of legal certainty or consistency with respect to review of alleged of disciplinary liability, of ethical violations?
Well, you need to regularly analyze the case law of disciplinary proceedings, of course, according to the authorities that the inspector may have, and to avoid violating those standards. Also, the inspector is supposed to draft decisions of the disciplinary chambers. So in the process of drafting those decisions, you also need to learn the case law of the Supreme Court and apply it in the way that will not conflict the current, case law. This is going to be the application of the principle of legal certainty. If I may, for me, after the Powell's questions, I want to add a yes or no question. In your view, avoiding ethical dilemmas, does it affect integrity?
Ну, саме уникнення, коли це здійснено свідомо.
Етичних дилем.
Ну, якщо це здійснено свідомо, то я думаю, що воно впливає на доброчесність. Може, я неправильно розумію ваше питання?
I think it affects integrity if it is done intentionally.
Продовжуйте. Можливо, в мене ще одне питання.
Yes, I will continue. I have another question still about the ethical dilemma, a really interesting topic. So, in your daily routine, don't you have any ethical dilemmas? In the daily routine, they do happen, but they're not related to my job at all. I'm not asking you about your job. Well, just like any person, they do happen. Well, thank you. That's alleviate my fears, because I really experience them every day, and I'm looking at you and think, well, that's kind of a guy without them. I've got a couple of questions about the property integrity of yours. You bought a car and you bought 49,000 hryvnias. It was an Audi. What kind of car is that, and where can you buy it? This car had not been used for a long period of time after a couple of traffic accidents, and the amount that I paid for and that we agreed on it, on this price in the agreement, it wasn't the kind of only price that I paid, because I needed to pay a lot to repair it. I still am paying for that because it still has a number of problems that require some investments. And this is confirmed. Do you have the agreement that Yeah, that indicates 49,000. Yes, yes, we signed the agreement with the appropriate authority, and it has this amount I indicated here. Another question. While you were working as an assistant judge, you received the license to practice law as a defense lawyer. How did you do it in time-wise? I mean, doing the internship and working as assistant judge. I wasn't a assistant to a judge. I was a chief specialist back then for the organizational support unit, and the internship gave me a chance to take this internship during the time that was free from my work. So I had the individual training plan, and I did it in my free time, so on the weekends or other time, because I wasn't required to be offline all the time, because for example, if I had to prepare draft decisions, I could do it at home. Who did you take the internship with? Mykola Gennadievich Kolda. Thank you. Now you are working in Kiev, aren't you? Yes, and you're living in Kiev, aren't you? Yes. Where do you live? Why do I have this question? Because the declaration of yours do not indicate the right to use. Indeed, as I said in my explanations, I thought that I indicated, they specify the place of residence and the address where I reside, and that the apartment belongs to my family members. It was enough to meet the expectations of the law against corruption and provide information for the register of declaration. So it's only probably my own interpretation that I shouldn't have done it. I may have made a mistake, but I indicated all the information about the apartment, who it belonged to, and so on. So this is the apartment of your mother. Yes, it is. And your family members? My mom and myself. Aren't you married? No, I'm not married. You've never been married? No, I haven't. Why am asking this question? Because we have information that you were married. No, never, ever. No more questions.
Short final remarks. Do you think that having an ethical dilemma is a bad thing?
No. I can't say it is something bad, because they may, anyone can have them in their daily life, of course, but you need to understand what kind of decision you make to find your way out of the dilemma, and the decision may be bad.
Do you think that having an ethical dilemma in professional life, in court, is a bad thing?
No, it is not something bad. And if it occurs, you need to understand what kind of decision you're going to make to find your way out of the dilemma, because it must be in line with the principles that should guide the work of a public servant. If the decision doesn't violate these principles and requirements, then I can't say it is something bad.
I see in your resume that you acquired the license to practice law and you suspended it immediately. Did you suspend the activities or also the oath?
Чи я зупинив клятву?
Did I suspend the oath? Yeah? I don't quite understand the question with the oath. You can't suspend the oath, can you?
You can't suspend the oath, right? You cannot suspend the oath.
Ну, наше
Yes, our legislation says that you can terminate your work as a defense lawyer if it is incompatible with your current position, but it doesn't say that you can terminate the oath.
I fully agree. So only the activities are suspended.
Так,
Yes.
так.
Yes, yes, indeed.
Imagine that you are a judge, but you will have also the attorney's license suspended. Is this okay or not?
Ну, якщо воно
Well, if it is suspended, it is okay. Let me explain. When I received the license, there was a case law according to which the fact of receipt of the license to practice law, provided that it is immediately suspended, it does not lead to any incompatibility issues. And I follow this case law that was once again it confirmed that it was totally legal. That's why I received the license and terminated.
From a legal point of view, it's absolutely clear. And now think about the ethical dimension. You have, as a judge, you have your oath as a judge, which wording of which is not exactly the same as the oath of the attorney, right? And since you can't suspend the oath of the attorney, you are under two oaths, the judge's oath and the attorney's oath. Isn't this an interesting ethical dilemma?
Well, from the moral ethical dilemma point of view, maybe there are indeed some issues about that, but from the point of view of legality of receipt of the license at the point when I obtained it, it was totally legit. So there were no legal violations in my view. Yes, there may be questions as to the dilemma when you take the oath of a judge and the defense lawyer attorney, but there are no violation of the law.
The part of questions is finished, so you have 2 minutes for your final comment or remark, and the interview will be finished. So thank you.
I don't have any questions to you. Thank you for your attention, and I wish you fruitful work in the future. Thank you.
This interview and participation in the competition, our decision will be made after all interviews, so of course you will be notified about this. So
Дякую.
thank you once again, and
Дякую.
good luck.
До побачення.
Добрий день.
Hello, Vitaly.
Today we are having interview with one of the candidates for the position of disciplinary inspectors, Mr. Vitaly Petrik. And first of all, I would like to introduce you with some rules of our interview before starting. So the interview will be conducted by the selection commission. I'm Reda Moliene, the chair of the commission, and the members of the commission are Yulia Bokova, Olena Kovby, Olga Popikova, John Ehrlich, and Pavel Zelinchik. Maybe you have any requests regarding the composition of the commission?
Немає.
No, I don't have.
We will have interview for about 60 minutes, about an hour, and we will ask you some questions about your professional experience, about your competences, and your insights about judicial ethics and integrity. And also you will have several minutes for your final comments after this. And due to limited time, please be as concise as possible so that we could discuss all things that we want to discuss. And also I would like to inform you that the interview is broadcasted. So if you have any information during the interview and we have to discuss the information that falls under restrictions of the martial law for public disclosure, so please inform the commission, and we will hold parts of the interview not in public. If you do not have any questions so far, so we could start the interview with your presentation and introduction about your background, about your motivation and your understanding of the mission of the service. The floor is yours, please.
Thank you. Dear Competition Commission members, to my opinion, one of the key elements of the independence of the judiciary is to establish the new Service of Disciplinary Inspectors. They will be responsible for ensuring discipline in courts of all instances in Ukraine. It's extremely important element to maintain a balance between independence of judges and their accountability to the society. They should perform their duly functions in duly manner, and a democratic state should ensure possibility for each citizen to respond and to react to any possible violation from the side of judges. Judges, as bearers of an authority, should act according to the standards of integrity, professional ethics, and law. It's unacceptable for the judiciary to lose the public trust because of abuse of powers. The system of disciplinary responsibility should work as a tool of increasing the quality of justice, as only in that case, when judges will bear responsibility for their actions, we can speak about their accountability towards the society. For now, national legislation should ensure uninterruptible, transparent, and fair system of bringing judges to responsibility. It will ensure to maintain understanding of society that each judge fulfills their duties in a duly manner and their actions correspond to the norms of ethics. One of the tasks of disciplinary inspectors is to ensure approval and making a fair and justified decision based on consideration of the complaint. It will lead to the increase of trust from the side of public towards the judiciary, and this is the key factor of maintaining public trust towards judiciary. The society should be sure that a judge is not only professional in their work, but also complies with ethical norms in their daily life. It will create conditions for renewing trust toward judges. The role of disciplinary inspectors is about ensuring functioning of the system where only highly professional judges with integrity will work. Real professionals who gain a decent salary and work in relevant conditions, and they are ready to give to public quick and fair justice. Inspectors will be guarantors that any violations from the side of judges will be considered immediately, and based on conditions and grounds, all judges will be brought to disciplinary responsibility. It will create an environment where all participants to the judiciary process will act according to ethical norms, and people will have more trust towards the judicial decisions. One more important aspect, that's a quick manner and fair manner of consideration of complaints against judges. Any delays or lack of objectivity in such cases is unacceptable. Duly, timely and impartial consideration of cases will ensure trust towards the system of disciplinary complaints. The inspector should work in such a way that each case should be considered quickly and objectively, and it will correspondingly will increase efficiency of the justice. Also, it should be taken into consideration that during consideration of a case, if there are no grounds for bringing a judge to disciplinary responsibility, disciplinary inspectors, in my opinion, first of all, should identify what are actions that were committed by a judge within the judiciary process, how the procedural law sets forth for inspector to do and how to act, what decisions should be banned and what should be adopted, whether a judge acted according to legislation, and if violated the legislation, what were the reasons, what were the motives for a judge. Motivation for a judge. To my opinion, considering of disciplinary proceeding, of disciplinary complaint, should be based on the following principles, even in spite of the fact that neither the law on the HCJ nor the law on judiciary and the state of judges doesn't ensure some principles for the disciplinary proceeding. So I would identify the following principles. The principle of legitimacy which is actually envisaged by the legal certainty of actions of a judge, and compliance of disciplinary inspectors with the standards of duly legitimate procedure while implementing, carrying out consideration of case against judge. Also, we shall ensure a realization of norms.
The principle of legal certainty, so clear certainty about the reasons why a judge behaves in a particular way and the procedures, appropriate procedures that he made. The procedure to determine whether the disciplinary misconduct has been committed, and that requires disciplinary inspector to analyze the circumstances of the case to understand whether to initiate a case against a judge and make the reasonable decision whether there are grounds to bring the judge to responsibility or to deny to bring the judge to responsibility. The principle of proportionality, so compliance of the punishment to the violation. The principle of irreversibility of responsibility, so a person, if he committed a violation, she should be punished. The decision must be well substantiated and based on true facts. A disciplinary inspector, while making decision on a case, must remember that it should describe the circumstances based on the actual evidence, because the issue of sanctioning a judge can be done only if the evidence obtained as a result of the analysis are clear and persuading to confirm the ground for the sanction. The evidence in the viewpoint of a reasonable observer must give initial substantial understanding whether there are grounds to bring a judge to responsibility. As to my experience, I want to say that after I graduated from the Yaroslav the Wise National Law Academy, I served in the military prosecution office, where I worked since 2005 until 2019 on different levels of prosecutorial office. Starting from 14 to 15, I worked in the General Prosecutor's Office. Since 2020 until today, I've been working with the Prosecutor General Office, where I represent the state's interests in court. as a chief specialist. My responsibilities as official belong to participation in court hearings in civil economic cases. In cases initiated following the motions of the PGO on different courts of different instances, I also submit procedural documents. I have experience of handling big arrays of data, and now I represent this interest of the PGO in over 70 cases. In talking about the variety of cases, there are a lot of cases related to the dismissal of prosecutors, about bringing them to responsibility or dismissal them from administrative positions and others. In 2020-2022, I would normally have up to 150 cases in the pipeline that where I needed to represent the interest of the state, because each case has a lot of information that needs to be processed. Also, each case requires preparation of appropriate documents for a claim or appeal claim and so on. And the preparation of these documents requires experience and understanding how to work with the unified register of court decisions, the e-judiciary and so on. Thank you for your attention. Thank you for listening.
Preparation for this interview and prepared presentation. Now we will proceed with the first session of questions, and I will give the floor to our commission member Olena Kovbi to start questions, and we will then proceed. Also. Thank you.
Дякую, пані голово.
Thank you. Madam Chair, I congratulate you, Mr. Patrick, on making it to this final stage. You have made it through 2 stages. Let's move on to the questions. You said you talked about your experience with the PGO since 2020, and you've been working a lot there, and in particular taking part in court hearings. Yes, Your Honor. Sorry for that. Has there been any case, or do you have any experience of filing complaints with the HCJ? Well, fortunately enough or unfortunately enough, I haven't got that kind of experience. Fortunately enough or unfortunately enough? Well, probably fortunately enough. So over these 4 years, you were fortunate enough to work with the judges who actually considered the case without any doubts on your side, without any intention to file a complaint with the HCJ. Yeah. So it's not that bad in our system eventually then, is it? I see you've prepared, thank you very much, but still, your opinion, what is the main aim for the establishment of the SDI? In my opinion, the main aim is independence and raising public trust, because the opinion of the general public depends heavily on media, and maybe the general public believes that if we talk about bringing judges to responsibility, if the members of the commission make the decision, and they are also judges, at least most of them. So in this case, some people may believe that there might be some bias, but when the SDI is established, there will be special people who will collect evidence, who will collect the evidence, and they are not judges. So they, I think, will be independent in their decision making. Maybe it's otherwise. There is a public opinion that they are biased or not biased. Well, I think they will be unbiased. So SDI, yeah, I mean the SDI, because you meant about judges and members of the HCJ that they were biased. No, sorry, I didn't mean it. Slip of the tongue. This service that is being established, is it in a support unit or is it independent? It's more independent. body, although it is established under the secretariat of the HCJ, but still the SDI considers complaints, makes the decisions, draft materials and submits it to the Commission on Consideration of Disciplinary Cases. The inspector takes part in the process, indicates who should be interviewed as a witness, collects evidence, determines whether there is actual the guilt, whether a person indeed committed a misconduct or not. An inspector, when he considers disciplinary complaint, is he a passive participant or an active participant? I think he should be an active. How should it be manifested? Well, because the inspector collects evidence, collects materials, he reports, he prepares, he drafts decisions, he
Зазначає під час
determines who should be listened to, what kind of witnesses should be interviewed. So basically he collects evidence that can serve as a ground to bring or not to bring a judge to responsibility.
сутності
If there is no evidence, or if the inspector unduly collects information about a person, then a judge may escape the responsibility if there is no evidence in place. Your professional experience is mostly related to the prosecutorial bodies. All your professional life has been focused on the prosecution authorities. Yes, indeed. Then tell us why is the role and the SDI so interesting for you? What's your objective? Well, over the past 4 years, I've been representing the interest of the PGO, and the majority of cases where I represent the interest are the cases where the prosecutors complain against them being brought to responsibility, appeal against their dismissal. So once there is a claim that's referred to court, this is actually the result of consideration of the grounds for bringing him or her to responsibility and for dismissal. So it involves collection of information, materials, evidence. So I work with the materials that are already prepared when the person represents them, present them, and I go to the court and deny the claims of the claimant. So and the inspector also, he collects information, he makes conclusions that may be grounds for bringing person to disciplinary responsibility, and I think that's going to happen. Certain number of people who are going to be sanctioned will also challenge those decisions in courts, and my objective on this position is to contribute with my experience and to learn something, so that a judge, if he is sanctioned or not, but in this case if he or she is sanctioned, so that it would be absolutely clear, so that he couldn't really challenge the decision, so that if the person is sanctioned, so it is done in a proper way. Okay, if in case of a positive competition and you are appointed to position of an inspector, isn't gonna be a step for you later to take position of a judge in the future? Do you have this idea in your mind at the moment? Well, I can't give you an answer right now. Well, maybe I hope I can work on this position for 5 years, and then later, when I realize and when I know how judges are brought to responsibility for what kind of actions, maybe in the future. Yeah, you mean you would know what may expect you in the future if you decide ever to be a judge. Yeah, that's about it. A course of actions. If, let's say, you are an inspector, you made it through all the stages, you are selected, you are appointed, and your leadership from the PGO approaches you, or maybe your colleagues, and they ask you to disclose information about certain disciplinary proceedings. And in the future, then they ask you not to include into the draft of your decision the information that you managed to collect as part of your job duties. Well, the only thing that I would advise my colleagues on is to file an official request, because this is an internal use information only. I will refuse, and I will advise them to file an official request, and if there are reasons or the grounds for that, they will receive the information in a lawful manner. But if they are not a party to these proceedings, then I will refuse to do that. But if the position of inspector doesn't give you a possibility to provide any information to anyone who is not a party to the proceedings. So no other actions except for the refusal. Well, probably I will inform my supervisor about that kind of situation, so that my supervisor could know about it. How about if they offer you some sort of award for that? Then I must inform my supervisor about that. Is that it?
Thank you. Dear colleagues, that's all from my side on this part of sections. Please, over to you, if you have any questions. Greetings. Tell me, please. You mentioned that the trust of the society to the Service of Disciplinary Inspectors will be higher because, as one of the reasons that you mentioned, that there will be no judges there in the beginning, at the beginning stage. But tell me, what do you think? Why retired judges can't be candidates for disciplinary inspectors? No, of course they can, and the law envisages that there actually there should be not more than 50%. So the law clearly sets this force. I was wrong saying that. Okay, tell me. So what is your opinion? Should retired judges be in the service of disciplinary inspectors? I think that that retired judges should be there because they are not sitting judges already now. So it would be right because, you know, retired judges have worked for long periods of time in the position of a judge, and they know how the court is arranged, how decisions are made, and so on. And decisions are made in procedure, so how decisions are made, actions are carried out, and what is actually done, because they were involved in carrying out administrating the justice. And what do you think? What should be the ratio between judges and non-judges? Sorry, I didn't hear your question. So, to your opinion, what should be the ratio, the balance, the ratio of retired judges and other specialists from other legal fields? Yeah, maybe 50-50, you know? Thank you. Greetings. Let's go back to the question, the issue of the public trust, how to increase the authority. Tell me, please. So, based on your professional experience, it looks like that you're a professional prosecutor. You have worked there so much time, that's your work. So, you know both reforms that happened within the prosecutor's offices and what was before, and preconditions, and what are the outcomes. So what do you think?
Пов'язані питання підвищення довіри
Are the issues of increasing public trust to the judiciary related to the issue in the need to increase the authority of the prosecutor's offices? Could they be separate? Could they just, live separately? What is your opinion? And if you know the statistics regarding the prosecutor's offices, what is the level of the public trust to the prosecutor's offices?
Я гадаю, вони
I think
вони частково
that they are partially related to each other, both those issues, because prosecutor and employees of the prosecutor's offices participate in criminal proceedings. They also represent
частково пов'язане.
the party in the process, so they are partially correlated. What is the statistics regarding the trust to the prosecutor's offices? It's hard for me to say. I don't know for now, but I don't think that this level of trust is very high, but I can't say it for sure. I don't know it.
А чи не здається вам,
Don't you think
що питання довіри
that the issue of trust to courts and the issue of increasing authority trust will be also further important for the prosecutor's offices, that these phenomena are definitely correlated? That's to my opinion. Yes, of course, I think that they are correlated, because if people trust prosecutors' offices, they will also trust courts. To my opinion, as our mass media in major publish information, publish mostly negative information because it's better perceived by the society. That's why I think that we need to provide more positive information, positive decisions, and positive actions for the society, for the public to see how courts and prosecutors' offices act not only from the negative perspective but also from the positive perspective. Tell me, please. What are the principles of professional ethics that you know? I mean, it's the work of the prosecutor's office, responsibility, legitimacy, fairness, justice.
скажіть, будь ласка, яким чином
Tell me, please,
процедура дисципліни
how the procedure of disciplinary complaints happens in the prosecutor's offices for now. So how does this procedure happen? So now, at the prosecutor's offices, we have qualification and disciplinary commission of prosecutors right now. So prosecutors consider cases against prosecutors. So this commission consists of 11 persons. 5 of them are employees of prosecutors' offices. 3 others are submitted by the High Commissioner of Verkhovna Rada on Human Rights. Also, there are also representatives of educational facilities, of the bar council, and someone else. I don't remember. This commission considers cases based on motions submitted to them by the heads of prosecutors' offices. Also, those motions include some grounds. Based on those grounds, the qualification commission checks the motion, checks the case, and also there is a regulation which actually envisage functions of this qualification commission, and also envisages grounds for making decisions whether to bring or not to bring to disciplinary responsibility of a prosecutor. If a decision is made to bring a prosecutor to disciplinary responsibility, as envisaged by the Article 143, a decision is made and it's submitted to the Prosecutor General, and based on this decision, based on Article 9 of the law on prosecutors' offices, and so issues a decision on bringing a prosecutor to responsibility. And who could be subjects of such motions regarding complaints against prosecutors? The subjects of motions, usually these are higher level heads of prosecutors' offices, but also citizens. Okay, thank you. Tell me, please, do you know the statistics? General statistics, general number of complaints which are submitted to this disciplinary commission again regarding actions of prosecutors? No, I don't know. 100, 200,000.
Ну, ми можемо припустити, що
Can we assume that the number of such complaints against prosecutors is much less than a number of complaints against judges? I think that yes, we can assume it. And how do you think? Why? So what is the reason for it? Prosecutors are more diligent in their work,
відсутня
or
довіра до комісії, яка розглядає
there is no trust to this commission who considers the case as a complaint? Why do you think? What is the reason for it? In my opinion, it's more related to the fact that the judiciary is more wide, is more scaled, you know, but scattered. There are more courts and judicial authorities, more judges, and more decisions are made specifically by courts. And as of now, prosecutors' offices represent interests of the state or citizens. That's why citizens reach out more to courts. If, for example, if decision is made, the citizen can't reach out to the prosecutor's offices to defend interests of the citizen. That's why in such a case, a citizen reaches out, so files complaint to a court to defend their interests, and that's why more complaints are related to judges' actions. Okay.
Я вам дякую.
Thank you. Thank you for your answer. Thank you for your questions.
As we see from your dossier, and you also presented your background and extensive experience in the different positions in the prosecutor's office. So usually when we have an extensive experience in one kind of institutions, either in court or prosecution or in private sector, this experience shape our views, our understandings, our even some qualities. So, and I believe that you also gained some qualities during this work. So, how do you think? What are the strongest qualities gained during your career, which would help you in this new position?
I think that that's responsibility, competence, ability to work in a team, quick connections, and to fair actions, and
There is always a side effect of
also sincerity.
practices, long practices and long experiences, that sometimes we have these qualities which are so deeply rooted, and some of them can become an obstacle sometimes for us. So do you think that some of the experiences or understandings of legal framework, etc., could be an obstacle? Do you find any of those?
No, I don't see any obstacles or which could prevent me from working in the position of a disciplinary inspector. I think that if I'm appointed to this position, I will carry out my work according to legislation, according to law, so I will make decisions in ground manner and justify it.
Nobody, I think, has any doubts about this, but for example, I can say that from the public side and from people who are not the part of judiciary or prosecution or other legal profession, sometimes it seems that prosecutor is a person who is more likely to punish, and this kind of characteristic sometimes is attributed to prosecutors. So my question would be, don't you think that sometimes it could be this kind of a nature of more punitive nature in your job could be kind of a dilemma for you in your new position? Just for discussion. It's an interesting discussion always. what is the nature of one or the other profession.
Ні, я гадаю, що
No,
ні.
no, I don't think, because prosecutors are not only punishing, they also they defend interests of the state in particular. That's why you can't say that if a person is a prosecutor, then he or she also only fulfills a punitive function. He's also a defender. If I may to say, I work also, as an attorney of the office. So some persons also reach out to the prosecutor's office with some motions, and I defend interests of the prosecutor's office and of the prosecutor general as a legal entity. That's why I don't see any problem here.
And maybe I will give the floor to you, and then if I have some time, I will ask some other questions. Thank you.
Thank you. Добрий день, Mr. Petrick.
Добрий день. Дякую.
Hello?
Yes, in your opening remarks, you indicated that you saw the service as intended to create a balance between the independence of judges and public accountability. And my question is, how do you see the role of SDI in protecting the independence of judges?
Захист незалежності. Я
Protection of independence of judges, to my opinion, when a disciplinary inspector makes quick, legitimate and grounded decisions regarding bringing or non-bringing to disciplinary responsibility of a person, and if there are grounds to discipline a judge when based on a motion of a citizen, and this person pays attention that the actions of a judge are not left unpunished. Judge was disciplined for committing some kind of an offense. I think that after such fact, both the public and citizens will see that other judges will not repeat the same thing, because they will understand that for the same offense my colleague was brought to responsibility. So yes, they will see that if a judge commits some illegal actions, there will be outcomes for it, and the citizen could reach out to the HCJ with a complaint regarding this judge, and this judge will be brought to responsibility. And I think in such a way there will be an increased level of trust from the public, and the public will trust more judges.
That addresses the second component of the balance, which is the public accountability part. My question is your comments about protecting the independence of judges. And my question is, how does the service, or do you see the service as protecting the independence of judges?
По-перше, я гадаю, що
First of all, I think that some part of complaints will have a purpose to discredit,
дискредитувати суддю, зобов'язати вчинити
to discredit a judge, to oblige them to make a correct decision. But if a disciplinary inspector makes a quick, correct decision and will refuse to consider this complaint, a judge also will see that he or she is protected from outside and will also make justified and grounded decisions.
Your career has been as a prosecutor, and just to follow up on my colleague's question, do you see the role of a disciplinary inspector as essentially equivalent to that of a prosecutor?
мабуть, не зовсім.
Maybe not completely, I think, because the field of activities is a little bit different and the role is a little bit different. It's not completely related to the activities of a prosecutor.
Can you distinguish those roles for me, please?
В діяльності дисциплінарного інспектора
A disciplinary inspector role
повноваження саме щодо
will
звернення
have
щодо
some powers
дисциплінарної
to consider
суддів.
complaints and regarding disciplinary responsibility of judges, but the role of prosecutor is more general, it's more widespread. And a prosecutor could be
Досудове розслідування
could carry out pre-trial investigation and could be a prosecutor or accuser in criminal proceedings. So it's different things. Also to represent interests of the state in a court. If a prosecutor approaches the court, then the prosecutor works in the court in the interest of the state or specific state bodies. So
трошки інші.
for me, it's a little bit different.
Could you discuss with me your familiarity with judicial ethics?
Так, да.
Yes, I can.
Суддівська етика,
The
вона
judicial ethics,
перший кодекс,
first of all, is envisaged by the Code of Judicial Ethics, and also a judge performing their functions should follow Bangalore principles, and this code should also meet requirements of judicial ethics, not only in professional life but also in personal life, and avoid any possible signs of behavior which could discredit him, even not in the case of the professional life, but beyond. There are some ethical norms and moral norms which should be met by a judge.
Thank you.
Так, дякую.
Good afternoon.
Добрий день.
I would like to start with one question related to your career. You were a prosecutor during 2014 and the Maidan protests. Yes?
Ні, я не був.
No. I was not a prosecutor in any case of the protests.
You were prosecutor during the time of protests. In 2014. You were holding the position of prosecutor or not?
Так, да.
Yes. In 2014, I had this position of a prosecutor.
Я працював на
I worked at that time in the military prosecutor's office of the central region. At that time, I had the role of a prosecutor prosecutor in the methodology unit, and actually any relation to those events which took place during the dignity revolution were not made by me and were not made by the military prosecutor's office. So we were not related at all to it.
Have you had a chance to view and watch or listen to the interviews yesterday with the candidates who were present here yesterday?
частково.
Partially, I watched some of them when I had this opportunity. Yes.
Sure. Thank you. So, please, can we exchange a few ideas? How did you perceive as citizen, the movement in 2014? As citizen first, and then I will ask more questions. But as you, as citizen of Ukraine, what did you think is going on?
Ну, мабуть, громадяни,
Maybe citizens
вийшли на ці мітинги не просто так. Мабуть, їх
were on those protests, on those rallies, not because of nothing, but maybe at that time, citizens who live in this country, they had such attitude towards authorities, and it caused population of Ukraine to go out to the streets and try to change at least something in actions and activities of the authorities. That's why citizens all over Ukraine, they gathered together in Kiev and they tried to change that order of the state of affairs and the order of actions.
You already described that within your unit you did not deal with any of those cases which followed after Maidan. Were there any cases against the military personnel who acted during Maidan which ended up in your department or your prosecutorial unit which was basically a case against the military personnel after Maidan or not?
Ну, мені по такій справі невідомо.
I don't know about such cases because I didn't work specifically in the unit which carried out procedural guidance or pre-trial investigation of the case.
My next question is, from all the cases related to the disciplinary process or ethics of prosecutors, which one you consider interesting enough to share your views on with us?
Всі справи, вони...
You know, all cases are interesting from different perspectives.
Значна частина справ...
Major part of cases where prosecutors bring to responsibility are brought to responsibility is related to the burden of a pre-trial investigation or because files are not timely forwarded to the court, and due to this criminal proceedings could be closed, and as a result of it, specifically if there was a notice of suspicion, this person has a right to some repayment from the side of the state because of such actions of a prosecutor. It means that it leads to motions on compensation of funds which were spent by this person, and it also leads to some losses from the side of the state. I can say like this.
Okay, and from judicial disciplinary cases or judicial ethics, can you name some case, concrete case, but of course we don't need to talk about names and circumstances, but type of cases in the judicial discipline area which you find interesting over the past, I don't know, whatever years you can remember?
Ну, мабуть, справа, зараз спробую згадати.
I will try to recall my memory right now. Maybe that's a case when a person who makes a decision
Визнання за особою право користування певним
on indeed accepting a right of a person to use some property. A person mentioned in the essential part of the ruling that yes, this motion should be satisfied, the ownership right should be approved for the plaintiff and should be recognized for the plaintiff. It was declared during the court hearing. Judge announced that ruling, but later when the ruling was printed out, it was said there that the plaintiff should be refused in the text section of their motion, and it means that first as an appellate court, so first of all that case was considered, so a judge who considered that case was delaying that consideration of that case without any grounds at all, to my opinion. It took 2 years for a judge to make a decision. Then, after the ruling was announced in the court hearing, this ruling was changed by the judge, and on paper it was different. This judge was brought to responsibility, and he challenged this decision in HCJ, in all other instances, but all courts only made a decision that yes, that the disciplined judge was disciplined legitimately. That was a non-standard situation.
In proceedings.
Not only delays, but also that the judge changed his decision. So in the court room, he announced that he satisfies the motion of plaintiff, but when the decision was ready and printed out, it said that no, the motion was refused to be satisfied.
Thank you very much. Do you please have one more in your memory judicial discipline case which you consider interesting? This definitely is interesting. I know about cases from other countries when it happened, and it ended up similarly when the verdict announced was different from the verdict delivered. But please, can you name one more? Any area of judicial discipline or ethics, anything.
Судді, зокрема,
Yeah, there is a category of decisions when judges make decisions without any grounding, reasoning of those decisions. So they do not motivate their decisions, do not ground it. And also there is another category of decisions when judges, while making decisions, do not inform parties to the process about this decision. For example, in my personal practice, I had such case, but I didn't reach out to the commission, but maybe, yeah, I had that possibility at the time, because the court of first instance satisfied plaintiff's demands to the Office of Prosecutor General regarding protection of dignity, and I, from representing the side of the Office of Prosecutor General, I challenged it, I submitted a complaint, but another court didn't inform any party to the process about their decision. But later we find out from the files of the case that actually they sent to us and to others their decision. The appellate court, because of the full-scale invasion, and as my challenge was done in December 2021, but the full-scale invasion started in February 2022, and this mentioned decision of the appellate court became known to me later, almost after 8 or 9 months after the decision was made by that appellate court, when the access to some registers was renewed. Anyway, despite of this fact, I challenged it in the Cassation Court. Cassation Court demanded materials. I also received some additional evidences why actually so much time passed, but more than 30 days. But I challenged it in the Cassation Court after 9 or 8 months. The Cassation Court agreed with my motivation, with my grounds, approved it for consideration, and agreed it partially in terms of payments. And the Cassation Court actually satisfied my motion for representing the Prosecutor General's office. The decision of the first instance court was cancelled, and yes, we were the winning party. That's our case.
Last question is just for my information. It regards your maybe working style. I realize that when you speak spontaneously, it's very concise and clear. Can you please tell me why did you decide that you will read the presentation at the beginning from the paper?
So I decided to read it out, maybe because in any case, there is some kind of, anxiety or worriness. I prepared myself to this presentation, but maybe to be more, tailored in saying my opinion. That's why I put it on paper and read it out.
Okay, thank you.
Continuing this question about the style of the work, I was wondering if you have difficult legal question in your case, in your job. What do you prefer? Either collect all kind of information, materials, and to study individually this case, and to try to find the solution, etc. Or you tend to discuss with colleagues, with co-workers, to find their opinion about this matter, and to come to the solution in those discussions, plus, of course, analysis of materials. What you prefer? What would you prefer?
Дякую за запитання.
Thank you for your question. First of all, maybe I will try to deal with this matter on my own. I will study legislative basis, case law of the HCJ. I will try to find answers to some of my questions, and when I elaborate my own opinion, if I'm not sure on that matter, maybe I will ask my colleagues on some specific situation. If there are some cases where I'm not completely sure, but as far as I think that it's, I can see that I can handle this independent analyzing situation.
The nature of the work of this disciplinary inspector, because in principle they are working individually, though of course discussions and interaction and about practices, it's very important. Thank you. And also one just a quick question about the most challenging difficulties in your work, that you find. What is the most difficult things in your work, apart from the huge workload, because it's always a difficulty for everyone. But apart from this, what do you find the most difficult?
The challenges and difficult job, they only stimulate and motivate me to conduct some actions, to self-educate myself, to learn something new, to increase my level of knowledge. Something difficult which I can't handle, I don't see anything like this. Any such things.
You are able to overcome those challenges, but just it's usually again somebody is getting frustrated when we are talking about conflicts in a team with co-workers. For some people it's not a problem, but the problem is to work and to have a lot of technical tasks, etc. So just it's a curiosity what kind of difficulties you find that, well, I do not like this kind of situations.
I don't see difficulties. For all my period of work, I worked in different teams. There were different issues that were solved. I don't see any, what could be such difficult that could become an obstacle to fulfill duly my duties. Thank you, dear Vitaly, for your answers. Let's move to the next part of the questions. I would like to say thank you again for all the answers that you provided to our questions. They are quite comprehensive, but for me personally, there is still an issue which is unclear for me. Since 2004, you mentioned in your declaration that you have been owning an apartment in one of the occupied territories of Ukraine. In 2021, you issued the power of attorney for 2 persons. Yes. But in your explanations, you mentioned that you don't know who are those persons, where are they from? No, that you don't have any copy of that power of attorney. Please explain this situation, how it could be that you are an experienced lawyer, you're an employee of prosecutor's office, and you don't pay attention, and you don't, remember about this, and you have this attitude regarding your own cases, regarding your own property. As I mentioned in my explanations, the issue is that in that apartment, the sister of my father lived there. So yes, I received that apartment according to the deed of the gift, but further, she kept living there in the temporarily occupied territory, and when the Russian invasion started, after the start of the Russian Federation's invasion into the territory of Ukraine, I didn't communicate with her. With whom? With aunt? Yes. So she died in 2021. Yes, but I tell you about the situation before 2021. Do you mean 2014 occupation? Because you mentioned full-scale invasion. I mentioned invasion. Yes. So she died in 2021. And just informing you that I was informed about this fact by my father, who maintained communication with her. She was born in 1938. She was around 80-ish years old. And I understand that I will never come again to the Crimea. And that's why I didn't pay attention. What actually is going on with that apartment? What is there in that apartment? Yeah, I hope that when Ukraine wins, and I will be able to return to that apartment. What was the goal to issue that power of attorney?
Батько попрохав, щоб
My father asked me
чи продано, чи перепродано.
for that apartment to be sold to those persons who took care after my aunt. So to sold, to realized, to gift it, or to gift, or what? So what is your purpose? To gain any income? Or to return into the occupied territories after their liberation and use them, or to give it as a present to those persons who took care after the own. No. I didn't get any income. My purpose was as persons who took care
Вони дійсно там.
after my own aunt are there, and the apartment is there, and I understand that neither me nor my father will never go there back, will return. So the purpose was for those people who took care after my own to use this apartment on the legal basis. But why do you are you sure that you will never come to the occupied territories? Because I already mentioned that maybe I will return within some period of time, but during that period of time, the department, the status of the department could be deteriorated, the conditions. Who are those persons to whom you issued that power of attorney? As I mentioned in my answers,
Батько підійшов, зазначив, що
my father reached out to me and mentioned those persons to whom I should issue that power of attorney. We came to the notary office, we issued the power of attorney, and my father took it. And so, if my father hadn't died, maybe I would ask him about it, but it was before the full-scale invasion. Okay, thank you. So, can you say, is it standard for you that even a father comes to you and asks you to issue a power of attorney to unknown persons to carry out some specific actions regarding your property which belongs to you, not to your father? No, it's not standard for me, for my behavior, but as I mentioned, I have not used that apartment for so long. I have had no relation to this. So the last time I had been to the Crimea in long time ago, and so you have no interest in your apartment, in your property which belongs to you. Is it right? In this case, no. In this case, I had no interest at all. Because it's located on the territory of the Crimea, and I hope that I will return back to that territory and will enter that apartment very soon. But what is going now with this apartment? Are you sure that as of now this apartment belongs to you? According to the register,
даного реєстру, вона так
yes, it's owned on me. That the state register on the immovable property, but the property right now on the occupied territory, purchase or selling of it is impossible if it was done illegally. I don't know what is happening there with that apartment right now, whether that house is there or not. I even have no person to ask about it. What is the period of effectiveness of that power of attorney? Do you remember it? I don't remember, but usually the powers of attorney are issued for several years. 1, 2, 3, 2 or 3 years. So to your opinion, as of now, this power of attorney is not effective already. I think that yes. No, the power of attorney is still effective till the end of 2024. So for 3 years, and it means... Okay, thank you.
Thank you very much for the questions are over. The interview is coming to the end, so you have 2 minutes for your final remark or comment. Please.
Шановні члени комісії,
Dear Commission members, thank you so much for this possibility to participate in this interview and to speak up about my opinions and thoughts. I was happy to discuss with you the issues of further activities of a disciplinary inspector. I hope that my experience and answers which I provided to your questions will facilitate the decision of my appointment to this position. Thank you.
And yes, the decision about the winners of the competition will be made after all interviews, so in 2 weeks period. So thank you very much. Good luck.
дякую.
Добрий день, пан Максим. Вітаємо. So today we will have an interview with one of the candidates for the position of disciplinary inspectors, Mr. Maxim Zakharchenko. So first of all, I would like to introduce our commission. I'm Reda Moliene, the chair of the commission. The members of the commission are Yulia Bokova, Olena Kovby, Olga Popikova, John Ehrlich, and Pavel Zelenchik. So we are in our entire composition. Today, do you have any requests regarding the composition of the commission or the members of the commission?
Зауваження відсутнє.
No requests.
We can proceed with our principles and rules of our interview. So it will last for about 1 hour. We will be asking you questions with regard to your professional experience, your competences, and your insights about judicial ethics and integrity. And at the end of the interview, you will have 2 minutes to 3 minutes to provide some final remarks or some final comments. I would also like to inform you that the interview is broadcasted, and if you have any information which falls under restrictions for its public disclosure under the martial law, please inform the Commission. Do you have any requests or questions so far?
Ні, наразі.
No requests or questions.
Then start and proceed with our interview, and I would like then to give a floor to you to make an introduction and presentation of your motivation, your background, and how you understand the mission and the role of disciplinary inspectors. So the floor is yours, please.
Дякую.
Greetings again to esteemed members of the Commission. Maxim Zakharchenko. I will start my presentation from my work experience, how I joined judicial system and prosecutorial system. I started working as a secretary in District Court of Dnipropetrovsk. Then I grew to the assistant to the judge. After judge was retired, I was invited as assistant to judge to the district administrative course. And when in 2016, when High Anti-Corruption Court started its activity, I participated in competition as an assistant to the judge, and I worked as an assistant to judge in High Anti-Corruption Court. At that time, I understood that I acquired considerable amount of skills and theoretical knowledge, and I wanted some procedural independence because, as you know, assistant to judge conducts a lot of big amount of work, but sometimes you want to be more. I personally wanted to more actively participate in court sessions. At that time, there was a competition to the Office of Prosecutors General. Based on the results of the competition, I got a position in the Office of General Prosecutor as prosecutor in the division. With regards to my motivation, when I saw the announcement about this competition, I didn't hesitate that I will be participating in this competition, because for me, I decided that having this combination of experience working both in prosecutor's office and in courts, having understanding of internal process of the system and working also as a prosecutor, I decided I can be a good candidate for this position. With regards to my vision on the goal of establishing SDI, I will not deviate from the tasks that are mentioned in the law on HCJ, that this service will be
implementing authorities on disciplinary proceeding regarding judges, and this will be auxiliary body, because even in what will inspectors will do? Inspectors will not be making decisions on merit, and to say that this service will restore trust to judiciary, unfortunately I cannot say that, because this will be a prerogative of the HCJ and its disciplinary bodies. That's it.
Member Olga Popikova to start our part of questions.
Доброго дня.
Good day, Mr. Maxim. Congratulations that you already at the stage of interviews, and let's talk about your personal motivation to work as inspector, disciplinary inspector. From the point of view of how you understand mission of this newly established service, how you see, please state your personal motivation. I want to start from example, how I learned about disciplinary proceedings with regards to judges. The first court where I was working, among the staff there were two judges who had already conclusions of the High Judiciary Council about violation of the oath of a judge, and from the very first days I was interested in which court that was. It was Kirovsky District Court of Dnipropetrovsk city, and from that I started studying how this procedure goes on, what are the reasons for holding a judge liable, and the thought about disciplinary proceedings was in parallel with me throughout my work as assistant to judge, because usually you track the practice of disciplinary chambers to inform judge and to for the judge to avoid certain mistakes that was conducted by other judges. And as a prosecutor, I also studied practice of HCJ on disciplinary complaints and in general, and that's why I understood that these topics are interesting for me. That's a lot of work to do for, but I believe that I have enough strengths, both theoretical and practical skills, and from my positive traits, I'm adaptable to new conditions. I'm used to work with large amounts of data. Please tell us, with having certain your personal motivation, and when you understand that disciplinary function should add to the trust of the judiciary, but you still completely put it on the High Council of Justice. But what will be the mission of the SDI? Only as serving as auxiliary function. So from the activities of SDI will not depend the tasks of the HCJ. Maybe I wrongly transferred responsibility totally on High Council of Justice. Of course, the final result will influence the the work of disciplinary inspectors will influence on final results, but it will be a joint effort, but the final decision is still made by the disciplinary chamber. and they have the final authority. In order not to go back to this issue, please tell me, is there a difference between mission and task of members of the High Council of Justice and disciplinary inspectors? If please outline those differences, this difference, if there is one. I think that mission of members of High Council of Justice is much more extensive. So it's like so there is a general one and special one, because disciplinary inspectors, they will assist to the mission of the members of High Council of Justice. They moving together, and there won't be that somebody will so the final goal will be common, but the tasks are you understand as goal, yeah? Okay, I understand. Currently, can you tell us what is your job function in prosecutor's office? Currently, what is I'm currently a prosecutor of methodology department, and my authorities are to study draft laws that are submitted to the office, and because I'm working department of oversight on security authorities, we work on issues of sanction lists, we coordinate with Ministry of Justice on provision of information, and before February I had a case in I was working on a case that was dragging from the long before, so during 4 years that I'm serving in prosecutor's office, I worked in 3 areas. I started at work in support of public prosecution. I worked in a department of oversight on regional prosecutors' offices, and now I'm working in technical department, methodology department. Thank you. My next question is about how do you feel that you have certain gaps in your knowledge that are related to work of SDI? If you have any, how do you expect to compensate them in the nearest futures? Maybe this question arises from your understanding of role of SDI, but because you received quite a low score during practical testing, yes, the results of practical test surprised me. I haven't so like when I saw the results, I decided to look other published works, and I saw that my work was scanned not totally, page 1, 3, and 5. At the same day, I wrote a remark to the secretariat, but I haven't received that answer. And with regards, do you feel that you have gaps? With regards to gaps, I will be honest. Unfortunately, I never worked in administrative process, and I understand if I will be working as a discipline inspector and I will receive a complaint that is related to the judge of administrative court, I will have to spend more time to prepare to work on the case. There will be more time for self-discipline, for studying new practice. And with regards to some basic knowledge, I think I'm quite confident in myself. Practice that is now built up in High Council of Justice on disciplinary proceedings. Do you study it? Of course, on a regular basis, course that I more or less know. I look through those cases, and then on the paragraphs of Article 106, I study them. So and of course you study the practice of the Grand Chamber of High Council of Justice. Yes, I studied the last digest. Which last case that you studied was the most interesting for you? And like, well, cases from the disciplinary case. Which case you like interested you or impressed you? From the latest which I studied, that's the case on the judge of the Supreme Court, judge of the District Court of Kiev Oblast, and the last one that I remembered, a case on the judge of Babushkinsky Court in Dnipro City. For myself, I revealed a lot of reasoning on how were drafted violations of that case. I will not comment because I was participating in one of those cases. You were interested on the content of the decision, or with the, or because these cases were publicly known, because they were quite high-profile cases, or because you were reading the legal reasoning that was put in the decisions of the SCJ. And so now it's not. There are a lot of high-profile cases. So I was studying the decisions, the reasoning with evidences that were used to reason the case. I understood. Please tell us what is your opinion about the prioritizing of disciplinary cases. Should we add something? Should this procedure be better clarified, or currently there is enough reasons how to prioritize cases? Because the functions of SDI will be like SDI will work as a primary filter, and disciplinary inspectors, they will be this primary filter, and they will be deciding which case should be prioritized. I think that reasons that are defined by the law and the rules of procedure on the prioritization of complaints, they're quite workable, and you can filter those cases that should be expedited in their consideration. Like the only thing is, with regards to the reasons on dismissal on the cases of dismissal of judges, I haven't seen if the judge is dismissed, maybe that can be a reason to just to dismiss the disciplinary complaint if it was filed against the judge. If the complaint, let's model the situation. If complaint is filed to SDI, and one of the reasons to consider it priority is its high public profile, and let's say you received 3 complaints. How you will define the grade of public importance, like information in mass media, or information about judge who might be like some audacious history, or complaint that is signed by a large number of complainants?
Look, the criteria of priority is the only one. That's the case, that's the attention society. What about this criteria? How to identify it? First of all, I would define for myself, and I would review the outcomes of each of such violations, whether there was any harm, damage to health or life of a person, whether indeed it harmed public interests, and how many people found out about it, how many people were negatively impacted by it. Usually, high public attention is correlated, is combined with dissemination of this information in mass media, and that's how a case becomes high-profile case. I think that it's not a correct thing. You need to dig into details of each case. Maybe for me, the most critical thing is outcomes. For example, if there is a car accident as a result of which a person died, and there is a decision, another decision where a land plot was transferred from communal to private ownership, that's of course a case with a deceased person would be a higher priority. The law does not envisage outcomes as a grounds for privatization, but there are some outcomes for judges, for a judge. So complaints where the outcome of the decision could be dismissal of a judge, it could be a priority case. Thank you. Okay, but tell me, do you know such notion, or can you comment upon it? So did you have any compromises with your consciousness? Yes. Thank you for an interesting question. Yes, there were some, and I think that they happen quite often, and even starting from my school years. You know, it's like when you're a pupil of a school, whether to go to leave the lesson with all of them, or stay at the lesson because you have only all A marks. So, you know, there's always such compromises, but that's about the volume, the extent of this compromise. Whether it's only for you, it's a small one, or it's indeed could impact on others, on the environment, on your family. So, yes, they were. Thank you. And what do you think? So, what do you think about this compromise with this feeling of the truth, with the consciousness? Is it your some kind of ordinary thing, or does it leave some kind of trace in your soul because of the hardships of having this choice? So, recalling in your memory such cases of yours, what do you think? I don't mean the school case when you miss your lessons. No, let's go to your adult life, maybe professional life. Without examples, so your feeling. You know, I learned to have a dialogue with myself and, you know, evaluate each position in terms of what could harm more, first of all, to me, and whether I agree with such harm. That's why, for now, I'm quite easy with this, because I know what is the order of steps, how to solve this compromise. And as I already mentioned, luckily or not, such compromises happen very often in my life, and they just keep me, you know, toned or alerted in life. Thank you. Thank you, dear Maxim. I could ask you so many questions, but I need to have a compromise and give a floor to my colleagues. Thank you. Thank you. Greetings. Tell me, please, what challenges for you at the position of a disciplinary inspector do you see? So first of all, that's the working load, that's a freshly established body. I was already employee of a freshly established body when I was an assistant judge of the High Anti-Corruption Court. And so, yeah, first of all, speaking about organizational issues, that's how to, you know, where our employees will sit, where a team will sit, how to ensure technical equipment, how to have this, you know, document turnover. I don't know what HCJ has, but I think that after the specialized document turnover in the specialized prosecutor's office, I can handle everything. So then regarding working on to prioritize, to distribute cases, so those cases which could be solved quickly, on, for example, on dropping the complaint, or which other complaints that should be opened and considered and further submitted for consideration of disciplinary chambers. So for now, maybe I can't imagine any other challenges. Okay, thank you. Tell me, please, what values are important for you at this work, at this job? First of all, maybe that's to be fair with yourself, because when you are fair with yourself, you will be fair, and you will be fair for other people. Discipline. I welcome so much people who do everything on time, and they're disciplined in terms of what they are doing, and they welcome it also in judges, because it impacts, it influences on the efficiency and speediness of the work. Tell me, please, speaking about efficiency and other things, speaking about efficiency and punctuality, is it the same thing? Could it be the same or not? It's like a reason and and an outcome. Yes, maybe a person is not efficient, is not punctual, but at the same time, there are persons who there are some persons, who could manage the huge workload, even if they are not punctual. Okay, tell me. Tell me, please, what moral criteria should a disciplinary inspector meet with? Should they be of high moral standards? Yes, of course, because requirements regarding disciplinary inspectors in terms of ethical and moral norms are those which are applied for judges. But you know that a judge, both in personal and working life, should be a bright example of a correct, and I'm not afraid of this word, behavior, of a correct behavior, yes, indeed. So these people should be of high moral standards, both as specialists and as human beings with their own values and correct life positions or views. Thank you. The next question, a small one. Tell me, please. So, do you think that for any ethical violation, ethical offense, a judge could be dismissed from their position or not? No, not from any. Can you comment upon it? You should differentiate. Again, so what this offense is, of which specific ethical norms, what were the outcomes, what were the circumstances of commitment of such offense? For example, if a judge, crosses the road on the red light, even if there are no cars, it's an offense of ethical norm, a violation of ethical norm, but we can't dismiss him for it. But if a judge is a drunk driver, so when he consumed some substances, and even if there had been no, police officer to pull him over, but anyway, I think these are already, so to say, conditional grounds to consider it as a violation of ethical norms. Thank you. Greetings, Maxim. I would like to have a clarifying question. You mentioned that you worked at the position of the assistant in the district court, Dnipropetrovsk district court. Okay, thank you. Tell me, please. You have already partially explained, but I would like to clarify whether I understood you correctly or not, that bringing a judge to responsibility for violation of ethical norms in the format of a dismissal of the judge is related only to circumstances of when outcomes of bringing harm happened, or when harm happened actually as an outcome of such offense. No. I think that it should be a combination of different criteria, whether it was intentional or not. So, was it intentional or non-intentional violation of rules? So should be a combined evaluation of different criteria, definitely. Thank you. And also, when you answered the question of Olga regarding cases which you remember the most, you mentioned the following wording, that for now it's difficult to be surprised. What do you mean? So I think that it's related to judges and some high-profile cases, or at large, that what is happening in the judiciary at large. And to continue, to your opinion, what is right now the level of public trust regarding the judiciary? My comment was related exclusively to my attitude to such high-profile cases. Maybe it's already, professional deformation, because I'm quite calm in responding to such cases. Yeah, so there is a violation, there is an authority which deals with it. I don't see any need to speak about it for several months, to remind about it, and in such a way, again, to undermine the public trust to the judiciary. So to clarify that for you, does it mean that it's such a routine, ordinary thing? I mean, what is happening in the judiciary, that you're even not surprised that what is happening there? Of course, I'm surprised, especially when there are such people who obtain such high roles and positions are involved and are in the intention of the judiciary. But I don't maintain that all the time very high public attention to it. I think it's extended. Of course, it's clear that after such cases, the public becomes anxious, and it's actually covered in mass media. For example, we can go to the website of the judiciary and we can find some cases there. But I think that public reminding about it just makes more harm. And what about the level of trust towards the judiciary? So what is your opinion regarding it? Can you clarify? So my opinion, or how do I see? Of course, your opinion, because the societal opinion, we know what it is. So my opinion, I think actually it's quite positive. It's very positive. For those 4 years that I've been working in the prosecutor's office, I have met judges usually of the courts of first instance. I was quite nicely surprised, and those judges which were appointed even based on the results of the competition back of 2018, they were called as young judges. They were very qualified. Processes always were done in a calm manner, with understanding. My attitude, even despite of my previous experience of an employee of the judiciary system, I could say that I have never faced those major part of the cases which are now covered in mass media when I was involved in the process. Do I understand you correctly, that you have experience to become to be a party to the court proceedings? Yeah, I participated as a prosecutor. Okay, thank you. Then tell me, have you had such situations when you reached out to the HCJ with a disciplinary complaint, or you had a wish, a desire to reach out to the HCJ with a disciplinary complaint? Frankly speaking, no. There was no wish from my side, and there was no such, even when I had such case with equitable ruling, and I used different other instances of the court, such as Court of Appeal and Court of Cassation, but I had no thought at all that the judge made some wrong decisions and I need to go with disciplinary complaint to the HCJ. Thank you. Just 1 minute, I would like to ask a question. Tell me, please, to your opinion, openness of the the process of consideration of disciplinary complaints, will it lead to a higher trust to the judiciary or not? To my opinion, it will increase the level of trust. So because, so to say, it's a dialogue with society, they could observe how it happens, because usually, actually, critics and claims usually happen because everything goes behind the closed doors, and it's not clear how it happened, where it went. And if you do it with broadcasting, to my opinion, it facilitates the renewal of trust, and I also mentioned that it also helps to have a dialogue with society. Thank you.
When you were talking about your career change from the assistant of a judge to prosecutor, you indicated this kind of motivation, that you wanted more procedural autonomy. And I liked your motivation because it was precise, clear, and accurate. And I would like to hear what is your this kind of precise motivation to go for this position.
Now, when I've got already everything what I wanted, I already was a judge assistant, and I already was an active participant or party to the hearings as a prosecutor. I understand now that, again, going back to my work at the prosecutor's office, why actually I was at all three areas of operations. In such a way, I understood what I like. And I understood that I'm a good doer. I'm good in working with huge volumes of information, with analysis, with generalization. So someone, should stay on the positions of procedural managers. They're more excited about having some searches, investigative measures, or other things, but others are doing those things. That's why, going back to what motivated me to apply for this position, that's maybe my understanding that, I can do it, I'm ready, and yes, indeed, I could be a qualitative and valuable employee in this service.
In your opinion, is the level or the level, the scope of procedural independence, procedural autonomy of the prosecutor in the process, in the court process, and the level of procedural independence, autonomy of disciplinary inspector in disciplinary case, in disciplinary proceedings? These are similar levels and scopes, or different, and if different, in which respect?
I think that indeed they could be compared, as both roles are independent and autonomous, and in terms of implementation of their legal requests, there are some protective measures and responsibility. For example, if you don't provide information or upon the request of a disciplinary inspector, or for the same, if there is a legal refusal to satisfy the motion of prosecutor. Speaking about other similar things, there is a presence of such duties in a specific proceedings. A disciplinary inspector has a disciplinary proceedings, and the prosecutor has some duties within the framework of the Criminal Procedural Code. The extent, the volume of such powers is envisaged by the law, speaking about differences. Again, taking into consideration difference of those proceedings. I mean, a disciplinary proceeding and a criminal proceeding.
Thank you. And maybe you can give us an example. You remember kind of a situation, either in your current position or previous position, because you were working with judges, preparing materials and your positions and conclusions. Now you also have kind of this activities as a prosecutor. Have you had any, I wouldn't say conflict, no, but debate, real legal debate with a judge or a superior on a particular matter? When you didn't agree and you were standing for your position?
Thank you for your question. Yes, I had such situations, both at my role as a judge assistant and at my role as a prosecutor. As a judge assistant, it led to, indeed, an interesting discussion, but of course, the final word was made by a judge. Who puts a signature, he is the leader. And when I was a prosecutor, I can't say that it was a conflict. Rather to say, when my leadership asked me, what about that specific proceedings? Why is the notice of suspicion is not signed? Or is there any missing document? And then I explained that at this specific stage, I'm missing, there is not enough evidence, or the expertise is under conduction. That's why I'm not ready to go further, to have some actions. I can't say that there is a huge debate or argument. No, everything is solved within the framework of a dialogue based on my position.
Passing the floor to my colleagues.
Добрий день. What is your opinion as to whether an incorrect decision of a judge should be grounds for disciplinary liability? So judge makes a decision, maybe it's just wrong, maybe it goes up in appeal and gets reversed. Do you think there are circumstances under which an incorrect decision should be subject to disciplinary liability?
Can I clarify? Decision went through all instances, and it was not. Was it cancelled or not cancelled? Was it dismissed or not dismissed?
Of the judge. So the judge was deciding, for example, who should own the house, or who should get the child's custody, or which corporation should have rights to minerals. And there's a challenge to it, and the case goes up on appeal. And the appellate court says you made an incorrect decision. Are there any circumstances under which you could see, or your opinion is that the judge could be disciplined for making a wrong decision?
If we talk about dismissal of judge's decision, there are no grounds for disciplinary proceeding. But when court of first instance was making this decision, there might be find out certain grounds for disciplinary liability. We cannot say that in case that if decision passed through appellation and cassation and was changed or not changed, that it will like not the content of the decision, but during when this decision was made, we cannot say that there were no disciplinary violations or offenses.
The court of first instance, do you think, might be subject to disciplinary liability?
In my opinion, all decisions on merit except procedural, where you appoint session, because from practice you see that decisions of investigative judges during pre-trial investigation were subject of complaints and decisions on merits of the criminal cases with convictions.
Criteria for indicating that this could, I guess.
Yeah.
Maybe.
Is he misinterpreting? Yeah. Okay.
Yeah, maybe you could repeat.
Yeah. So what I'm trying to get at is there, if a judge makes a decision, are there circumstances under which his decision-making could be an ethical violation, subject to disciplinary liability?
If I understood you correctly, independently whether decision is appealed, whether it's lawful or unlawful, are there reasons? And if any case is considered under judge's consideration, are there any inactions during making decisions, during consideration of case for which the judge can be disciplinary liable? I think that at every stage when a case is in the judge's proceeding and under considerations, there can be reasons, grounds for disciplinary liability, and Mr. John is asking what can be such situations when judge can be held liable irrespective of his decision. For example, extra procedural communication with the parties, unethical conduct outside court chamber, or invitation of one party to the judge's room and other party observes that. Actions of a judge that might influence the circumstances that later can become subject of disciplinary liability.
What is your understanding of the role of the disciplinary inspector?
I want to say that, in my opinion, this is active participant of disciplinary proceeding. It performs initial actions on preparing materials, on establishing witnesses, evidences, submits requests, double checks circumstances of the case. Its role, maybe we might say, might want to say it's auxiliary to prepare conclusion and submit it to the chamber, but at the same time he is a participant of this proceeding. In my opinion, it's a synergy between participant and those who a party that prepares material.
I'm going to ask you to just clarify that last statement that was made, which is you said it's a synergy between the participant and the party who prepares the materials. Did I understand that correctly?
Yes. Inspector participates in the session of the disciplinary chamber as an active, of this proceeding, and before that she collects materials.
Good afternoon. Let's follow up a little bit on this conversation about responsibility for decision, disciplinary responsibility related to judge's decision. I think I got your answers. You were mostly referring to the appellate process. So the decision is here, then the appellate court did something about it. So you didn't see direct link between decision and disciplinary liability. Now, I would like to ask one question. If a judge announces a verdict, and then in the written form, the verdict is different. Judge announces in public the decision, but the written version says something else. This is a case which can be appealed, or can be disciplinary sanctioned, or both. What do you think?
Моя думка.
My opinion, we see disciplinary violation, and at the same time, parties can use their right to appeal this decision. With regards to the actions of the judge, in my opinion, there are reasons for disciplinary liability.
The ground. What did he do wrong? What was the basis? What is the violation? What did he breach?
Зараз хотів швидко сказати.
I wanted to ask fast, but like
Сказати,
I want to say that if decision was announced, only appeal or cassation instance can change it. But if there is a mistake, technical mistake, like misprint, so that then it's the court who should change it. The violation is finality of the decision.
I don't want to spend too much time with this issue, although it's very interesting. But let's say that it was not a mistake in writing or typo. The judge says he is guilty because of this, this, and this, and the written version says something different. I'm not going to specify more, but it's clear that it is not a typo, that something happened between the announcement and the written verdict. There was... What is this? If this can be an ethical violation, and if yes, what obligation did the judge violate?
я якраз пригадав.
So I'm just recollected. I think there is no final decision on the judge of Dnipropetrovsk District Court. There is such a proceeding when was announced one resolution, and in written form there was totally different. And if I'm not mistaken, according to the resolution of the disciplinary proceeding, the judge was not incriminated, but like the judge violated paragraph 3, 4 of part 1 of article 106. Yes, if I'm not mistaken, paragraph 3 was opened at the initiative of disciplinary chamber. Can you tell to our tell to our colleagues what are these paragraphs? Paragraph 3 provisions responsibility for gross violation of ethical norms that
really, you told me actually more than I asked for, so I'm really satisfied. Thank you very much. Now, do I have time for a few more? So only a few. You mentioned one very interesting thing when speaking about the cautiousness. You said that you held a dialogue with yourself about harm. Internal dialogue. This is a super interesting phenomenon. Can you be more specific? How does it look like?
Я перепрошую.
I meant monologue. If it's dialogue, it's something from psychiatry.
I would take both. I would take both. Please, how does it look like?
Як це?
Монолог виглядає.
Monologue looks like this. So like list of questions. What was what caused this situation? What are my action plan, possible actions? What will be consequences if I do in this or that way? Will I harm me or my environment or people around me? Like if there is this compromise is possible, or maybe I was mistaken. I saw the possibility for it in place where it shouldn't be. So can I avoid this? If I cannot avoid, how to do it with least harm in influence to me and to people around me, to my health. So
I have no further questions.
Thank you and we will come to the very last part, which will be short, I guess. So please.
Колеги, Максим.
Colleagues, Maxim Sergeyevich, he provided answers to the minor questions that were asked to him on the lease of the vehicle. So you acknowledged some mistakes on non-declaring certain information, but that doesn't mean that you tried to hide this information. The only question I want to ask is, please tell us about charity benefits. This is related health related issue. Okay, then we skip it. And 3 sentences. What was your motivation to participate in public organization, legal association of Dobrosud? This was year 2021 when I decided to join this organization. I was appealed with the goal of their activities, because this is association of candidates, judge candidates, judges, retired judges, and mostly they conduct webinars. They invite judges of Supreme Court from HQCJ. So it's a dialogue of those who want to aspire to become judges, and those who already are judges and who are retired judges, who can share information. Yes. So they don't invite members of High Council of Justice. That's a joke, of course. Thank you for your answers.
I think this is an interesting platform mentioned now, the association Dobrosud. And I think it offers, since we have some time, interesting deliberation about this issue. I consider the interprofessional dialogue between various legal professionals very healthy, very important, eye-opening, super interesting mostly. At the same time, it brings some challenges, because people from various professions get together. There can be a reception in the evening, there can be some wine, there can be various levels and scales of friendships. I'm not now speaking about Dobrosud, but I'm speaking about the interprofessional dialogue. How to identify when is the moment when people, for example, meet on these occasions regularly, prosecutors and judges know each other, and then they meet each other in the courtroom. Would you like to offer your interpretation about when such a relationship may cause conflict of interest or ground for recusal or self-recusal, what would be the criteria under which you would assess this is too much? This is okay, this is we don't know, and this is too much. Can you offer some criteria according to which you would be dividing this line?
Thank you for your question. I will try. I think that in the situation when, for example, there are two members of the same civic organization meet in the court, one of them is a judge, another is a prosecutor. And first of all, we use the preventive measures envisaged by the on counter-corruption legislation. So we disclose this information. Speaking about criteria, I think it's quite hard to identify such lines without having a general picture or general circumstances. Because, you know, when your motions, such as all of them, are satisfied, even if they are grounded, but it could cause some suspicions, because to the opinion of another party, your motions are completely unmotivated. And how to prove that here there are no grounds for disciplinary responsibility, that we acted exclusively within the framework of procedural norms? Maybe communication beyond the procedural environment could become a criteria of defining this line, where the line is crossed or not. But for me, unfortunately, I don't know any specific, clear such lines or requirements. Maybe to observe within the process, beyond the process, to provide evaluation of actions, of what is happening immediately in the court.
How would you define integrity?
To my opinion, integrity is such a general notion which includes also other notions of moral, of ethics, of behavior in society. And the integrity unites all of them and gives such, you know, and again, that's my opinion, to my belief. It gives such, you know, such an exemplary example of a behavior, and which has no violations of any norms, such a standard. But at the same time, to my opinion, you know, in order, it's so hard to achieve such integrity, to comply with 100% with the integrity criteria. It's almost unreal, to my opinion.
Thank you very much.
But we won't. We strive for it.
Thank you. We already finalized our session of questions, and thank you very much for your honest answers and being open in your you know, comments and discussion. It was really very interesting. Now you have 2 minutes for your final comments or remarks. Please.
Thank you for this wonderful interview. It's so great. From the beginning, I wanted to mention, when I entered into this room, all of you smiled to me, and immediately it elevated all of my worries. It was so comfortable and nice to work with you. I wish you fruitful work. Let the best of us be the winners of this so important competition. Thank you for your attention.
Decision will be after all candidates will be interviewed, so in 2 weeks we will announce the decision. Not in 2 weeks, maybe a bit earlier, like at the end of the next week we will finalize our interviews. So thank you very much and good luck. Добрий день, пані.
Good afternoon, Irina.
We are today going to proceed with interviews, and we have one more interview with a candidate for the position of disciplinary inspector. And first of all, I would like you to introduce to our commission. You will be interviewed by the selection commission. I am Reda Moliene, the chair of the commission. The members of the commission are Yulia Bokova, Olena Kovby, Olga Popikova, John Ehrlich, and Pavel Zelinchik. Do you have any requests regarding the composition of the commission?
No, I don't have any.
So the interview will take about 60 minutes. We will be asking you questions about your professional experience and your motivation, and also your insights about the judicial ethics and integrity. And at the end of the interview, you will have several minutes for your final comments. One important technical aspect of this interview, that it is broadcasted, and if you have any information, and this information should be discussed during the interview, which falls under restrictions for its public disclosure according to the martial law, please inform us in order to take according decisions. So maybe you have some questions before we start.
No, thank you. I don't have.
So
Thank you.
we can proceed with our interview, and first part is your introduction and presentation of your background, your motivation, and your understanding of the mission of this service. The floor is yours, please.
Дякую.
Thank you. Dear Chair of the Commission, dear members of the Competition Commission, I will start with a few words about myself. As of now, I work at the National Yaroslav Mudry National Law Academy, and since 2022, I have been working as an associate professor of the Department of Criminal Procedure, and before I worked at the other various departments of such judicial and law enforcement authorities, and also worked at the University Department of the judiciary status, and then all those university departments were amalgamated into the university department of the criminal process. At such university department of criminal procedure, I teach such subjects as judicial systems and comparative judicial law, and some other subjects. Those disciplines actually stipulate the area of my interest. In 2013, I had a dissertation, and I defended it on the subject of bar activities and the judiciary, and based on that dissertation I also issued the monography, and then I received a PhD, and actually that's what I have till now. Speaking about my motivation to participate in this competition, I could say the following. As de facto from the very early student years, I was always interested in all areas or in all fields related to the judicial procedure, the status of judges and the judiciary system. So as soon as the competition was announced for positions of disciplinary inspectors, I decided to try myself and participate in this competition. We understand now that the judiciary and the judicial system in Ukraine has been in the permanent status and condition of reforms since the very beginning of independence of Ukraine. We constantly make changes and amendments to the law, to the constitution of Ukraine. We increase requirements regarding those persons who take positions of judges. Within the judiciary system, we create specific bodies which should be responsible for selection of judges, and also regarding bringing judges to disciplinary responsibility according to international standards.
Just in order to be able to translate everything that you, because we want to understand everything that you are presenting. Thank you.
I'm sorry.
Can I continue? Yes. And always, that's about the fact that in Ukraine our national legislation is so good, but it was approved and adopted according to international standards and recommendations. But the only problem that we have, that legislation always should be implemented by specific subjects, by specific entities. And unfortunately, those entities, those subjects are not always maintain this high level of authority and high level of quality of legislation that we have in Ukraine. We would like to establish, to create the ideal model of the judiciary, and in order to achieve it, now we are having the competition for judges of appellate courts and for judges of the High Anti-Corruption Court. But at the same time, we also understand that persons who will be selected and appointed as judges at those bodies could make some unprofessional, unethical behavior, and it actually undermines the authority of the judiciary. And to my opinion, the Service of Disciplinary Inspectors will have, among many other its tasks, one such task which actually is about preventing for judges, for persons to continue as judges if they do not correspond such high standards, high societal expectations, and to prevent some other things. That's why I would like to contribute at least a little bit to this process. Thank you.
You can put the just to feel comfortable during the interview. So we will start then our session of questions and discussion, and I would like to start with my question would be: you mentioned that you have a PhD and you have defended your dissertation, which is related to the judicial system and judiciary. Could you please specify a bit, elaborate on the topic of your dissertation? What were the most important fields of interest in this dissertation? Thank you.
Thank you for your question. The topic of my dissertation is the principle of unity of the judiciary. It means that the name itself says to us that somehow it's related to the judiciary topic. And this work and this dissertation, and actually I wrote it during 2009 to 2012, it was very on time in Ukraine, because in Ukraine at that time there were so many different specialized high courts because of the ungeneralized case law in Ukraine. That's why my key area of interest in that work was on the following. On the legislative level, we declare the principle of unity of the judiciary. In particular, we mention that the unity should be envisaged by specific provisions and guarantees, such as unity of principles of organization and activities or functioning of the judiciary bodies, unity of the status of judges, unity of the activities of the judiciary self-governance authorities, funding of judiciary bodies exclusively from the state budget, and some other principles.
I in detail analyzed these provisions. I provided certain arguments regarding whether it's necessary further extend that principle of unity of the judiciary based on its importance. That with various explanation of each element. For example, when we're talking about unity of the status of judges, in my work I mentioned following components of this principle and the guarantees that should be adhered to, such as unity of basic requirements to the candidate, judge candidate. Of course, law can provision certain additional or extended requirements to the judges of higher instances, but the basic requirement should be unified, which is now put in the Constitution and in relevant legislation. Next component, it's unity of the procedure of selection and appointment of judges for their positions when we're talking about same judicial positions. If we talk about the position of Supreme Court judge, all the candidates to this position should undergo same procedure of appointment, same according to the same objective requirements to the candidate. And I reasoned principle of unity of the status of judges with same duties and responsibilities. Of course, they might in amount they depending on the specialization, but the rights and duties, responsibilities should be the same. And for example, unity of procedure of dismissal of judge of his powers.
Your presentation, especially in the last part, you mentioned that also you analyzed the system in some respect of judicial disciplinary liability. Yes, so you are aware of existing system and probably you have some, from the academic perspective, some insights what should be or could be changed in this system, both institutionally and or procedurally in the system of disciplinary liability.
Дуже дякую за
Thank you for your question. I want to say that legislation in comparing to the legislation that was in place in years 2010, 2011, it was changed, and in my opinion, it changed to the better. Why? I will give an example. At that time, when I was writing my PhD thesis, there were two subjects of disciplinary liabilities for judges who can hold liable. High Judiciary Council, that was later renamed High Council of Justice, and High Qualification Commissions of Judges. And that created great problem with unity of the practice on how judges could be held disciplinarily liable, because two different bodies they could evaluate same situation in different manner. There was no unified foundation basis on the decisions on holding judge liable. There was no particular strict direct criteria, extensive reasons for holding judge liable, and that's so so that created problems. So currently this situation is improved for better. We have one body that can hold a judge disciplinary liable, and that's how it is.
A new body, I would say, is established, or will be established actually, the Service of Disciplinary Inspectors. So it indicates that probably there were some shortcomings in existing system. What shortcomings the disciplinary inspector service would help to overcome, if, and maybe you don't see any.
Дуже
Thank you for your question. Very interesting and quite subjective question. Currently, we cannot make conclusion, for example, by analyzing and generalizing practices of this body, because it's not yet existing. It's not. We can only make conclusions with regard to potential challenges that service newly established body will face. In my opinion, one of major challenges will be activities in getting unity of the disciplinary practice, achieving it. Activity of High Council of Justice, even they're working on disciplinary proceedings, but we still have a lot of complaints and make decisions on a large number of complaints, and we will have to study previous practice by persons who will be appointed disciplinary inspectors. Previous practice of activities of disciplinary chambers of High Council of Judges, to be able in their activities be guided by the principles of rule of law and justice. Yes, of course, persons who will be appointed as disciplinary inspectors will have a large amount of cases to consider. So these cases should be somehow systemized, decisions to be made. So these challenges I see.
Service, how do you envisage the role of disciplinary inspector? Yes, the functions are just established by the law, but just in a few words, how you see this scope of work and yes, and maybe role of this inspector.
Дуже дякую.
Thank you for the question. According to the law on High Council of Justice, which says that SDI will be an independent structural unit of High Council of Justice that will be delegated partially a certain amount of functions of High Council of Justice. Currently, we can say that disciplinary inspectors will face a lot of circumstances that they will have to settle and decide upon. We're talking about relations in the among the peers, relations with the deputy and head of the SDI, relations and communication with the members of High Councils of Justice, establishing internal communications, and issues of we will have issues of extended study of disciplinary practice, especially by persons who never had previous experience in that.
In the process of handling this disciplinary case, the specific disciplinary case. So what would be the exact role of disciplinary inspector when the case is heard by the High Council of Justice, by the Chamber of the High Council of Justice?
Добре, дякую.
With regards to the internal role of disciplinary inspectors, number one, it will be active role, because according to the law, disciplinary inspector will have to collect materials, prepare requests, prepare a draft of procedural documents, submit them for consideration of the disciplinary chambers of High Council of Justice. In my opinion, we can say that a role of disciplinary inspector will be in certain a role of certain role of independent arbiter. We can say that main tasks of disciplinary inspectors will be to find information that confirm fact of committing by a judge of disciplinary violation. But at the same time, disciplinary inspector has to comprehensively study all consequences of the case, and if possible, establish circumstances that will testify to absence of disciplinary offense by the judge. So it will be active role, it will be large scale, multifaceted. Yeah, that's how I see it.
To come to some personal question about your personal motivation again, because you told that you have particular interest in all kind of questions related to judicial system and also the disciplinary liability and other things. And from your dossier, I assume that you were considering the career of judge, because I saw that you were trying to apply for a position of the judge. This consideration was just one-time attempt, or some other conditions changed your career path, not to go for a position of a judge, but to start here.
Дуже дякую.
Thank you for your question. I submitted my documents for competition of judges 2 times, in 2017 and this year. In 2017, I submitted documents for a vacant position of a judge of local court out of interest, like scientifically reasoned reason. At lectures, we students consider all nuances of this procedure in order to be somehow acquainted with the procedure from inside. I submitted a document, but in 2017 the competition commission decided I don't have necessary experience to continue participation in competition. However, according to certain documents, at last year of my postgraduate program, I conducted lectures and I had relevant number of hours that can count my last year of postgraduate program as the sufficient time to have professional experience. And this year I submitted documents for the position of the judge of High Anti-Corruption Court. Here I cannot say you anything because I have no information about the further stages of that competition.
Questions, but I would like to give a floor to my colleagues to ask questions, and then we will see. So, Julia, please.
Вітаю, пані.
Greetings, Miss Irina. To continue with the question of Miss Rena, you applied for the competition of the High Anti-Corruption Court, and as we know from mass media, this competition will be quite fast, and maybe by the end of the year it will be concluded. If there will be, you will have to choose between a position of disciplinary inspector and judge of High Anti-Corruption Court. Thank you for your question. At this moment, if I will have to choose between possibility to, if I will have to choose between information that I'm approved for the position of a disciplinary inspector and so far some vague possibility of to become a judge of High Anti-Corruption Court, I will give preference to the position of disciplinary inspector. No. If I will decide to be disciplinary inspector, I will quit the competition for Court of High Anti-Corruption Court. I want to go back to a question on the changes to the legislation. You mentioned that in years 2011, 12, 13, there were significant changes to legislation on disciplinary proceedings, and I want to remind that the turning point was case Volkov against Ukraine, which mentioned systematic violations by Ukraine, and also indeed there were cardinal changes in legislation with regards to disciplinary proceedings. One of the requirements of the law and one of the function of the member of the High Council of Justice of that edition before the changes was that member of the High Council of Justice has right independently open a disciplinary proceeding. Later, law on restoration of trust to judiciary, this norm back in 2015 was excluded. Tell me, what is your opinion about this change? Thank you for the question. With regards to the option for the member of High Council of Justice to open a disciplinary proceeding case against the judge, I don't see anything bad in that. I will explain why. Number one, member of High Council of Justice, they are at the high level, are acquainted with the legislation, and then can open the issue of whether judge is liable for some disciplinary proceeding. And because High Council of Justice not only participates in the process of disciplinary consideration of disciplinary cases, but why, if and they're making decisions, and what prohibits them from initiating that such cases against judges, but provided they self-recuse and that member doesn't participate in the proceedings of that disciplinary case. And European Court in case Volkov against Ukraine said this is violation, and one body cannot combine the function of the complainant and the function of body that makes decision. Yes, but this scientific concept and the practice of the European Court of Human Rights, they can differ in certain manner. In Ukrainian legislation, we have a lot of examples that certain combinations in one bodies of certain functions are considered not desirable. But in this case, we are not talking about fact that one person, one member of High Council of Justice is seen as the whole body. If that member doesn't participate in that procedure without any influences, requests, and other things, I think this is possible theoretically, as a theoretical concept. Don't you think that this might be an influence on the independence of judge? To answer you to this question, we need to have some additional fact to this. We need to consider issue based on particular situation. Yes, of course, we can consider this as a possibility to influence the judge, as a possibility to influence High Council of Justice. However, there should be some guarantees of independence of the procedure on how the judge is held liable, and independence, objectivity, impartiality of member of the High Council of Justice in the context of our procedure. This is about independence and impartiality of the Service of Disciplinary Inspectors who will be part of that procedure. In my opinion, considering that all guarantees of independent, comprehensive, and study of the case, we can say that not always we can consider that as influence to the judge's independence.
Tell me, please, what value has the decision of the European Court for disciplinary proceedings? According to legislation of Ukraine, the case law of the European Court on Human Rights is accepted as a source of law in Ukraine. So as a source of law, it should be applied by all state authorities and other subjects in order to have these activities complied with all the standards and legislation. Thank you. The last question. Can you give any examples? I'm sure that you have analyzed legislation in terms of disciplinary proceedings. So can you give any examples which you would like to suggest to be implemented in Ukraine regarding the area of disciplinary proceedings, disciplinary complaints? Maybe some European examples. Thank you for your question. Actually, as of now, I would not be able to suggest anything new or something which is drastically more qualitative than what we have right now in our legislation. So you think that the procedure of disciplinary complaints, specifically Articles 106, 109 of the law on the judiciary, is perfect and includes everything what could be applied? I'm not ready to say 100% that they are absolutely ideal and perfect, because my actual practice shows and could show that, yes, there could be some gaps, but you know, some principle, drastically new things which works definitely more effective in other countries rather than in our country. No, I can't give you any examples. Thank you. Thank you. Greetings, Irina. Tell me, please, do you have any practical experience of working in the judiciary bodies? Have you participated or have you attended any court hearings or participated on during consideration of court cases? No. Thank you for the question. I don't have such experience, such practical experience. Thank you. Tell me, please, what do you think? Why do you have such not very high score for practical assignment? Actually, yeah, for me it was also, some kinds of I don't understand, so some kind of secret. Maybe I didn't have enough time. Maybe I was not attentive enough. I don't know even what to say. Because, I don't have there are no published objective criteria with which I could compare it. I can't give you more accurate answer. Okay, thank you. Tell me, please, why do you think that you are appropriate for taking the position of disciplinary inspector? Thank you for your question. And actually, the position of disciplinary inspector right now is a very important position. I would like to take it, to have it, as all other candidates in this competition. I can't say that other candidates for this position, they are less worthy. No, I agree that there will be candidates who will be more worthy, more appropriate than I am, who will have a higher number of years of working experience, or working in the relevant similar fields, or maybe even in the judiciary system, or have experience of working with disciplinary responsibility. But I would like to have this opportunity to use this knowledge that I have actually teaching in the university, so to contribute them into the practical area. And that's why I consider this opportunity for myself as a very interesting and very important one. Thank you. Do you have understanding of what is the volume of disciplinary complaints will be transferred to the new service? If I'm not mistaken, this volume is so huge. That's around 10,000 of complaints of cases, and we will have only 24 disciplinary inspectors. And of course, I understand there will be significant working load. Speaking about myself, I could say that because of the nuances of work as a lecturer at the university, and because of the nuances of the whole work that I needed to do in order to write a dissertation and my monography, as a major part of candidates, I can handle the huge volume of work. I can systemize that volume of work and which should be done. And I'm ready to learn new things. Thank you. But you understand that, you will have no time for this learning process. Yeah, I understand. Don't you think that specifically this lack of practical experience, of that you don't know at all how the judiciary and judges work, how documents are compiled and behavior and so on, will become an obstacle for you to start immediately doing your work? Thank you for your question, dear Lena. And speaking about drafting procedural documents, some procedural documents I could draft on the theoretical level. We have relevant subjects at our university. Speaking about in-depth work and processing of the information, which will be actually the topic of a disciplinary complaint, I could say that the specificity of my work now is the following: that there are some scientific issues, academic issues, some response to requests, which we do, which we submit or file. It also envisages work and processing of huge amounts of information, and it also requires in-depth review of this or that matter. That's why, from this perspective, I could say that some skills on comprehensive reviewing of information I have. Yeah, thank you. But you know, it's not only about comprehensive review of information, but also implementation. Thank you. And then last question in this part, which I would like to ask you. Please tell me the key your features which will help you to implement the key goal of this service. And to your opinion, at the end of the day, what is the key goal of establishing of the service, not by law, but to your opinion? Thank you for your question. So, to my opinion, one or maybe one of the key objectives and purposes of establishing of the service is to ensure development of highly quality, highly professional, highly moral, highly ethical number of judges. Because, you know, bringing to disciplinary responsibility could be considered as one of the elements either of increasing of professionalism of judges, and from some kind of perspective, and also as an elimination from the system of those persons who do not correspond to high standards and norms for professional judges in Ukraine. So the goal, the purpose of service is to develop, the number of judges, no, to foster this, to foster such creations and development of highly professional judges. Okay, and what are your key features? I'm goal-oriented, as we shall understand that each work has its own objectives and goals of its functioning. We shall understand those goals, and we shall do small steps and go step by step achieving them. And also this not uprightness, and maybe I'm not tolerant to the lack of professionalism. I'm not tolerant to impartiality, to lack of objectivity. Also honesty. I could describe myself as an honest person. Thank you. Greetings, Irina. I would like to ask you some questions regarding activities of the service, but I'm not going to ask them. And let's ask other questions. So the experience is definitely a very important thing. But anyway, we gain that experience at our different positions. Whether it would be useful or not, we can only, you know, speak hypothetically about it. But at the same time, I have a question to you. You know that selected inspectors are selected for 5 years. I mean that this period for their work is only 5 years. Why do you think? Why it's only 5 years? Because, you know, for those 5 years, those people, whether they will become highly professional, they will know everything, do everything, but only 5 years, you know. What is your personal opinion? What was the reasoning? What were the ideas of our legislators to limit our inspectors in their appointment for such period? Thank you for your question, dear Olga. Speaking about this period of appointment of a disciplinary inspector, maybe a legislator saw in it some sense, some you know, frankly speaking, so maybe some meaning, but I didn't study the purpose of it. But your opinion? So my opinion, there could be several reasons. First reason, that's maybe some such limitation of a period for appointment for this position will allow an option for a person working in this role as a disciplinary inspector to understand whether he or she handles such volume of duties, whether he or she can or cannot fulfill this job, and if a person, if after those 5 years, a person is the one who understands all the nuances and details of disciplinary complaints, he or she could apply for the next period. If not, then I understand that this person could also stop working at this position even before ending of that period, but maybe a legislator had in mind such nuances as such details, maybe to decrease the number of disciplinary complaints in future, or maybe to create some additional filters and decrease the working load of this body. So the reasons could be, but 5 years, of course, to identify whether a person suits or not the role, it's quite an extended opportunity. But maybe to think about it from different perspectives, that such periods of time for appointment eliminate some risks. What about it? What do you think about it? Yeah, in some aspects, yes, it's possible. Look, those risks could be related to further lack of objectivity or independence of a disciplinary inspector, because our legal landscape, unfortunately, gives us evidences that there are so many notifications, and both in the judiciary and in the prosecutors' authorities, that regarding independence of such employees, of such persons who hold such positions. So maybe this establishing of such period for appointment of a disciplinary inspector is one of the preconditions to avoid possible potential corruptional risks. Thank you. Thank you. That's all from my side.
Дякую. Добрий день.
Доброго дня.
Good afternoon.
During your introduction, you introduced yourself in saying that you taught and have studied criminal law, judicial systems, and comparative judicial law. And my question is whether the comparative judicial law has ever focused on judicial ethics.
Дякую за запитання.
Thank you for your question. Comparative judicial law, that's a subject which is called and which I actually teach in the university. Of course, it's not focused on the comparative of some ethical foundations in this or that judiciary system. We shall understand that some ethical foundations are based on the level of international standards, and they implement in different countries using different models. That's why we can't speak about significant discrepancies in those requirements for moral standards for regarding judges. We can't say about it.
I'm sorry, I need you to repeat that last part. We can't say that what about moral standards for judges, standardization for moral standards?
So I am speaking about that there are international documents which establish some specific foundations for moral and ethical requirements to judges. So in current democratic societies, even despite of all discrepancies in the design of judiciary systems, in some professional requirements to candidates for the positions of judges, but based on international standards, ethical requirements are more or less similar.
I see what you're saying. Okay. And What international standards are you referring to?
First of all, that's Bangalore principles for behavior of judges. And also there are so many other things as Montreal Convention on Independence of Justice, and also European Charter on the Law of the Status of Judges, and key principles of independence of the judiciary authorities, and also some indirect requirements for judges also could be envisaged in other more general documents, such as maybe the Convention on Protection of Fundamental Rights and Freedoms of a Person, and so on.
You talked about issues of unity and uniformity. What is your opinion as to whether in disciplining a judge, the same misconduct should always give rise to the same discipline or sanction?
Thank you for your question. According to the principle of the unity of the judiciary, which is envisaged by law, we have this unity of grounds and procedures for bringing for judges to disciplinary responsibility. So based on factual circumstances which are the same, judges should be disciplined, and according to the legal interpretation and legal certainty, the same sanctions should be applied against them.
Let me give you a couple examples and ask you if you think that there should be the same sanction. So in the first situation, a judge has been on the bench. He's been a judge for 2 months, no, let's say 6 months, and has a case that was heard before him right after he took the bench, and he still hasn't decided the case. And it involves child custody. Who's going to get the child, the father or the mother? In the second situation, a judge has been on the bench as a judge for 20 years, and there's never been a delay case involving this judge. 6-month delay in a case of a breach of contract and whether the homeowner owes money to the contractor. Both 6-month delays, do you treat those the same?
If I understand correctly your question, so the same should be grounds and procedure and disciplinary sanctions, but if the signs of or elements of disciplinary offenses are different, so a judge committed one action, another judge committed absolutely another disciplinary offense, we can't compare them because the disciplinary offenses are different. And if, for example, based on your example, there is a judge who actually has been on the bench only for 6 months and another who has been on the bench for 20 years, and they commit one and the same disciplinary offense, then according to legislation, they should undergo the same procedures of disciplinary sanctions, because if the principle of unity is not maintained, then we have no objective guarantees for independence of judges, and then they will consider it will be considered as some kind of disbalance of more guarantees for one judge and less guarantees for another judge.
I understand that should be considered previous employment of judge, character of the offense, subjective part, objective part, whether there were disciplinary sanctions to the person, a judge before. But if like the basic criteria should be should have same status. Can I give another example just to in a
With
Він,
Laska.
if I will extend a little bit. If a judge 20 years is working on the position and the case is about who will be guardian on the child, and the mother it's alone in this, and for 2 years the judge is not passing the case for consideration. Thank you for the question. If I understand properly, so the question if there are reasons for judge to be for disciplinary liability of a judge. Yes, I see here reasons, because we see violation of reasonable terms of case consideration, and we need to comprehensive consideration of the case. Yeah, thank you, John. Sorry if I interrupted.
Follow up on the discussion about the shortcomings in the current system. High Council of Justice deals with disciplinary cases. The discussion is whether it is okay if one body builds the case, collects evidence, finds what's in there, identifies witnesses, and the same body decides. And if I understood correctly, you said if the one person who collects the evidence is somehow separated from the other persons of the same body who make the decision, then it is okay. Did I understand correctly?
Thank you for the question. If we talk about disciplinary inspector,
about current system at the we speak about current system at the High Council of Judges.
We talk about that member of the High Council of Justice is submitting disciplinary complaint, and then he is separated from this structure. Then my opinion in this matter is we at certain stage, even like at initial stages, we are not talking about separation, because it's we're talking about submitting certain complaint, and consequences of this complaint should be same as if it came from any other person. There should be some preliminary check of the complaint. There should be additional requests for information, questioning of people, persons, providing opportunity to the judge to explain situation, and then there will be a procedure of disciplinary proceeding, and there will be collegial decision about further fate of this complaint, and there could be two ways, two options. High Council of Justice collegially, disciplinary chamber can see reasons for judge holding liable and applying sanction on a judge, or they will not see reason to apply sanction. But this will be collegial decisions that will not be tied to the first opinion of a certain person should initially recuse himself and not participate in that process.
If the High Council of Justice panel, Senate, as an institutional structure collects the evidence, one may think that there is something like institutional pre-understanding of the case, because it is not the same like when in front of a deciding judge, a case is brought, he was not involved in the collection, in the witnesses, in the reports. He just sees it with a fresh mind and decides. In the current system, as I understand it, the case is built and decided by the same body. Isn't this a problem?
Thank you for your question. In my opinion, in this, like in some particular case, everything should depend on actual circumstances of the case. There can be different situations, different legal reality. Sometimes we might say that preliminary opinion of a member of this state body theoretically might influence positions of other members and might influence collegial positions of this body. But at the same time, we can look at it from other aspect. Because every member of the authorized body should be independent, should be impartial, objective, and independently, comprehensively study circumstances of the case, and shouldn't be tied with opinion of his colleague. So here we should extend this issue into the plane of proper execution and of his or her responsibilities by members of this body.
Correctly, when describing the role of disciplinary inspectors in the new system, you used the word or words, inspector is an independent arbiter in that case to determine whether it happened or not. Did I remember it correctly? Yes?
Yes.
If it is so, I have follow-up question. If we have independent arbiter in the person of inspector, why can't he decide the case? Because why we need two independent arbiters, first the inspector and then the disciplinary panel?
Thank you for your question. Maybe I wasn't. Maybe the word arbiter was not very relevant to that position. But disciplinary inspector, functionally he should be independent subject in the procedure of disciplinary proceeding against judge. His activities should be characterized by independence, objectivity, impartiality, legality. I meant that disciplinary inspector should, in according to these principles, study all circumstances of the case in accordance with the complaint that was submitted to the High Council of Justice with information about improper behavior of a judge. That's what I meant.
Part of questions about the professional aspects of the activity is over. So now there is a part about the integrity, related to integrity, and we had several questions. We submitted to you those questions about your declarations and property declarations, asset declarations. You provided your answers, and those questions were responded. I would probably have one question regarding your declaration of monetary assets of 2023, where you indicated some amount of savings in this declaration. Though it could be the impression for the external observer that this amount of savings does not correspond precisely, or there are some discrepancies from the income, from the amount of income. And you provided additional explanation, and you provided explanation that there was not one source of income, not just a salary, but also some other sources. And I'm wondering, and I'm curious to know, maybe you could specify a little one of those sources that you indicated. This is payments received from charitable foundations and international organizations. So could you please explain what kind of income that it was and the nature of it? Thank you.
Дякую за запитання.
Thank you for this question. Because now in Ukraine we are facing full-scale aggression from other country. Many international organizations provide support to persons who are now internally displaced persons, or in this or that manner suffered from this aggression. And so the charitable benefits, this was monetary support from international organizations. They're working throughout Ukraine and provide support to internally displaced persons.
You indicated some other sources. It's also funds from your parents, and you explained that in total these different sources allowed you to have this amount of savings that it was declared in Declaration 2023. Thank you. You responded to my question. Now I will give a floor for a question from Pani Olene about the declaration of your family members. One question.
Дякую, пані Рада.
Thank you, Ms. Reda. Please tell us, in which year did you receive these benefits from international organization? In 2022 and 2023. Then why you didn't declare it in 23? I don't have. I have no declarations for 2022. I have declaration for 2021 and 23. So the funds that I had accumulated by 2023, I was receiving both in 2022 and 2023. So the payments, did you receive in 2023? But why they are not in the declaration? The matter is that according to the clarification of the NACP, monetary support from other organization is not supposed to be declared. That's why I was not declaring it. And without surnames and details, you're declaring your husband. Do I understand correctly that he resides at one of the occupied territories? He's residing in Kharkiv Oblast in city Pisochin. Do you reside together? No. Does he help you with raising child? Do you receive alimony? Since full-scale invasion, he lost his job. He has issues with finding new job. So actually, no. Another short question. In your 2023 declaration, you don't mention any value of your immovable property. Thank you for this question. The matter is, as I explained, I don't possess this information. I'm not hiding this anyway information, and I'm not trying to somehow hide it from relevant bodies. So this is immovable property, house with the garage. Our family privatized this property. Privatization was conducted free of charge, and no one did a monetary evaluation of that property. Just not to waste our time. Do you understand correctly that this residential house of 313 square meters you privatized? Who was the body who privatized it? In 90s, Oblast branches of Ministry of Justice helped to judges who were working at the time to build their own residential houses. So because my family member was a judge, and Minister of Justice helped to build that building, and then it was privatized. All supporting documents I provided in my explanations.
Our interview is coming to the final stage, so now you have a couple of minutes for your final comment. Thank you.
Дуже дякую, шановні члени комісії, за те, що надали мені можливість.
Thank you for esteemed members of commissions to explain my position, and thank you for such a nice conversation, and I wish you all the best and fruitful work.
And we will announce our decision in a period of 2 weeks after all those interviews will be over.
Okay. Thank you very much.
Дякую, дуже дякую. До побачення.
До побачення.